medicine?
You can put your hand down now.
Oh, no.
Oh, sorry. How old are you and how far have you gone in school?
32 years old and I completed 12th high school.
And are you able to read, write, and understand the English language?
Yes, ma'am.
And do you understand that you are currently charged with the following offenses? Count 1 and 2, aggravated assault with a deadly weapon, which the state will be reducing for purposes of a plea to simple assault. And counts 3, battery family violence. Counts 4, possession of firearm during the commission of a felony, which the state would recommend to be null pros. But do you understand that those are your charges?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Alberja, about all the facts and circumstances known to you regarding the charges in this indictment and any possible defenses?
Yes, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Mr. Alberja, do you waive formal reading of the indictment?
Yes,
Do you waive any and all defects in the indictment?
yes, ma'am.
Mr. Walker, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Mr. Alberja?
No, I know not. No.
Okay. Has your attorney advised you of the minimum and maximum sentences for each charge that you are pleading to?
Yes.
The minimum and maximums for counts 1 and 2 are 1 year to 20 years. Battery, family violence. One moment, Your Honor. Which is a misdemeanor, is maximum is 12 months, and possession of a firearm during commission of a felony is 5 years. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after another. Do you understand that?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked on you entering a guilty plea today?
Yes, ma'am.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of the government until or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that?
Yes, ma'am.
And do you understand that you're not allowed to possess or use a firearm on probation?
Yes, ma'am.
Do you understand that you're not a United States citizen? A guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would. And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Parole? And no one can guarantee parole no matter what anyone has told you. Do you understand that?
Yes, ma'am.
And do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just like there would be after a conviction following a trial? For example, your guilty plea conviction may affect the right to vote, the right to hold public office, the right to serve on the jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Okay. And do you understand, excuse me, Your Honor, one moment. It is my understanding from the conversation of Mr. Alberja that he would like to plead under First Offender
Yes.
Act. Is
Yes,
that
ma'am.
correct, Mr. Alberga?
It is correct. You're correct.
Okay. So, Mr. Walker, are you
Yes.
actually treated as a first offender under the provisions of the First Offender Act?
Yes,
Have you ever pleaded guilty or nolo contendere to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
no,
Have you ever been sentenced for any crime, felony or misdemeanor under the provisions of the First Offender Act?
no,
And has your lawyer explained the First Offender Act to you?
yes,
And do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be
Yes.
adjudicated guilty, and you could be resentenced up to the maximum for this indictment? Do you understand that?
yes, ma'am.
Now, do you understand that if you went to trial, you have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand that?
Yes, ma'am.
And do you understand that by pleading guilty, you are giving up the following rights? The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial. Do you understand that?
Yes,
Has anyone forced you, threatened, or promised you anything to get you to enter a plea of guilty?
no,
How do you plead to the amended charges of count 1, simple assault, family violence, and count 2, simple assault?
guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
yes,
And do you understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
yes,
Your Honor, Mr. Walker does not have any felony convictions that I show. As to the plea negotiation, the state moves the court to null pros counts 3 and 4 of the indictment. In addition, if this case had proceeded to trial, the state would have expected its evidence to show that on June 28th of 2019, officers responded to 1590 Brewer Boulevard in Atlanta, Georgia, to a dispute. Upon arrival, officers met with Miss Jaleesa Hillman, who at the time was the girlfriend of Mr. Walker, and also Miss Alice Walker, who is Mr. Walker's sister. They both told officers that Mr. Walker became upset with Miss Hillman as he found out that she was in a relationship with another male, and he struck her several times in the ear, causing her ear to bleed. Mr. Walker's sister, Alice Walker, saw the assault and yelled for her brother to stop. Mr. Walker struck his sister in the bottom lip. They reported to police that as they were leaving the property, Mr. Walker pulled out a handgun and pointed it in the direction of them. Pictures of their minor injuries were shown on body camera footage. After this police report, Ms. Hillman told our office, the prosecution's office, that Mr. Walker, in fact, did not have a gun. And therefore, we are null prossing. That's the reason for null prossing count 4 and reducing counts 1 and 2 to the simple assault, given the injury to Ms. Hillman's ear and to Ms. Walker's lip.
And then why is count 3 being null prossed? Or did you not? So we've got 2 aggravated assaults that are being reduced to misdemeanors. The aggravated assaults allege pointing a handgun at, but if you're dismissing count 4, which is possession of a firearm, counts 1 and 2 make a little less sense because those aggravated assaults were not predicated on Mr. Walker striking either Ms. Hillman or his sister. They're predicated on the handgun pointing. It's count 3 that is based on Mr. Walker striking Jaleesa Hillman, Jalissa, who is the parent of their child. So I'm not trying to upset the apple cart. I think you get the same outcome. But if the state believes or is abiding by the victim's recanting the claim about the gun, then it seems like counts 1, 2, and 4 ought to be null prost, and the misdemeanor sentence you're pursuing would ride along count 3, which seems like the right fit. Family violence battery. Mr. Walker, angry at his girlfriend because he believed she was cheating, struck her. That's sort of classic family violence battery. I'm not trying to undo what you guys put together. I'm just trying to follow the facts as you explain them and the charges in the indictment.
Yes, Your Honor. I was under the impression that I could just reduce counts 1 and 2. However,
you can. No. I want to be clear. You can do that. I just wanted to make sure you understood. And it sounds like you do, that the counts you're reducing, the elements would be that he pointed a handgun at someone, and you're saying there wasn't a handgun. So I'm like I said, I'm not going to get in the way of it. This is a reasonable negotiated resolution. I was trying to understand really the reason why you were dismissing count 3, the family violence battery, which sounds like the one thing that everyone agrees did happen in the case.
Hopefully, Judge, it's not too late to accept your perspective and your opinion, and that I have no objection to that observation. And I don't know, Ms. Baser, what she thinks about that. It would simplify the matter too.
I mean, she's in charge in the respect of, and you know this, in terms of what she'll move to null pros and what she'll reduce. That is not a judicial decision. That's prosecutorial discretion. And I wasn't questioning her. She knows more about the case than I. I was trying to understand it, and I gave my little speech. So, Ms. Beza, I apologize if I've muddied the waters here, but I just was trying to understand the process.
The waters are not muddied, Your Honor. Part of my process in my mind was also to get a protection order for Alice Walker, no violent contact. However, if we can add a protection order for Alice Walker, I'm totally fine with pleading to count 3, but then adding the protection order to Miss Walker as well, and then a family violence intervention program.
Great.
Which is what we discussed in the negotiated plea. But my mindset, you asked what I was thinking about the protection order.
Sure. And I'll make that a condition, the no violent contact with Mr. Walker's sister. Okay. So
And
Mr.
with
Walker,
Hillman,
yeah, and definitely Ms. Hillman. Mr. Walker, what your lawyer has negotiated in terms of like what your sentence is going to look like isn't changing in any way, but the counts to which you are entering a plea is changing. You're going to be entering a plea to one count. It's count number 3, which is family violence battery, the allegation that you struck Ms. Hillman. You're not entering a plea to counts 1 and 2, which were aggravated assault, and Ms. Beza was agreeing to reduce them to simple assault because those allegations involved the gun.
Okay.
Count 4 was already going to be dismissed, which is you having a gun in connection with those felonies, because the state explained to me that even though initially either Ms. Hillman or your sister may have said, hey, he had a gun, later on they said, no, we were just mad at him. He was acting a fool and we were going to make life complicated for him. But they backed away from that. Do you understand what's changing in the plea? It's not the sentence, but it's the count to which you're entering a plea. You understand that?
Yes, sir.
You still want to go forward?
Yes, sir.
Okay. So Ms. Beza, if you could pick up where you left off, please.
Yes, Your Honor. For the state's recommendation, just for the record, will be null prosing counts 1, 2, and 4, and having Mr. Walker plead to count 3, which is the misdemeanor, battery, family violence. In addition, we negotiated no violent contact with Miss Jaleesa Hillman, who is listed in count 3, and further Miss Alice Walker, and family violence intervention program as part of probation.
Tell me, Ms. Beza, your understanding is that Ms. Hillman wants to continue to have contact with Mr. Walker. That's why you're saying no violent contact. I understand brother and sister, no violent contact makes sense because they may be at a family event or something. But Ms. Hillman is someone who still is okay with Mr. Walker showing up, or it's because they have a kid?
Both. I've spoken with Miss Hillman at length, and as well as Miss Walker. Miss Hillman actually told me that she doesn't need a protection order at all.
Okay.
And some other choice words. So we came to the conclusion that we would have no violent contact with her.
Okay, got it. Ms. Montgomery, do you have any criminal history information for Mr. Walker?
No, Your Honor.
Okay, thank you. Mr. Alberga, what do you want to tell me about Mr. Walker?
Well, very little else, Judge. You've done an excellent analysis. And the one thing that I would like to point out, that there was a recommendation for a 2-year probation. Now that this amendment has taken place, probably we now can look at less time.
1-year probation.
Right, it'll be months, so it'll be 12 months probation.
12 months probation, right?
Yeah.
So that, and I don't know if it's a reporting requirement, but we'll see what the probation, seeing that his record is spotless up to this point, whether there's a need for him to be reporting in view of the fact that he's living with one of the previous complainants, if you like, and that there's peace with his sister and himself. Maybe there is no need to be reporting. I don't know. If the judge would, if you would take that into consideration.
Mr. Walker, are you working these days?
Yes,
What do you do?
I work for the Cobb County Sanitation
How long have you been there?
since 2015.
Oh, long time. Okay, good for you. And you're living with Ms. Hillman right now? Or you're living with your sister?
No,
Neither.
neither.
Neither one. Okay. Do you live in DeKalb or in Fulton?
14.
In Fulton. But you still have contact with Ms. Hillman.
Yeah, we have a daughter together,
One kid? What's your daughter's name?
Cameron
Cameron?
Walker.
How old is she?
She'll be 6 on the 19th.
All right. Early happy birthday to Cameron. Are you still, so you have contact with Ms. Hillman because of Cameron? Are you guys on okay speaking terms?
Yeah.
And then your sister, Ms. Walker, I assume is someone you have contact with? Not so much.
Not so.
That's a complicated relationship.
No, it's good. Just don't talk.
Okay. Is she in the Atlanta area?
No, I think all Evans don't know where she stayed.
Okay. All right. Do you have other family in Atlanta or just Cameron?
No, I have. What you mean, my kids?
Kids or parents or brothers or sisters?
A lot of family members.
Okay. So you've got a support network here.
Yeah.
All right. Got it. Mr. Walker, first offender is an opportunity primarily. It's an opportunity you qualify for because you have no other convictions. If you are sentenced as a first offender, then you actually don't have a misdemeanor conviction. When you leave here today, you'll be under sentence for probation, but it's not a conviction. So if you are under review at work because you're looking for a promotion or a raise, or you're looking for a new job or something, and you get one of those applications and it says, have you ever been convicted of anything? The answer is no, because this is not a conviction. That's the opportunity of first offender. It's also a risk. If you get in trouble for something else while you're on first offender probation, you can not only have to deal with your new case, you can have your old probation revoked, and you can be resentenced as someone with a misdemeanor conviction without a trial. We've already had the trial, if you will. You came in here and pled guilty. And so I'd need to find that you did do something new, but let's say you got a DUI. If Ms. Beza brought this case back to say, look, Mr. Walker's on first offender probation, he got a DUI. Judge, I think you should take away his first offender status. I could put you in jail for a while for violating probation, but I could also take away that first offender status, and then you would have the misdemeanor after all. Do you understand that?
Yes, sir.
Okay. Knowing the benefit of first offender and the possible risk, do you still want to move forward as a first offender?
Yes, sir.
Okay, I'll do that. I find there's a factual basis for your plea to family violence battery. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to go forward. You may not be excited about it, but you've decided this is the right way forward. Is that correct?
Yes, sir.
And a knowing plea just means that you know or understand all the things we've been talking about. Do you have any questions about anything we've talked about so far?
No, sir.
You feel like you understand it?
Yes, sir.
Okay. Then I'll accept your plea. I will sentence you as a first offender. I will sentence you to 12 months probation on count 3. A special condition of your probation is that you complete a family violence intervention program. It's a series of classes that will help you deal with situations like the one you found yourself in a few years ago with Ms. Hillman. And also no violent contact with either Ms. Hillman or your sister, Ms. Walker. That doesn't mean you can't call them or write them or anything like that. You could even get into a verbal argument, but it can't get rough. Nothing like whatever happened in this situation. Understood?
Yes, sir.
All right. We are working off a copy of the indictment rather than the original. Mr. Alberga, any objection to moving forward with a copy of the indictment?
No objection, Judge.
Okay. I will be electronically signing the indictment for each of you. Mr. Walker, in normal times, you'd sign it yourself. Do you authorize me to sign the indictment indicating your guilty plea to count 3?
Yes, sir.
Mr. Alberga, may I sign on your behalf?
You may, Judge. I don't know if you can copy my signature.
Nope, it's not going to look like your signature. Actually, people will be able to read it. Ms. Beza, may I sign on your behalf?
Yes, Your Honor. Thank you.
Great. That will take care of almost everything. The last thing, Mr. Walker, that I've got is that you will get information through Mr. Alberga about how to report to misdemeanor probation. It's not, we have someone from probation on this call, but they supervise felons, more serious charges than what you pled to. And so you'll get information about where you need to go to say, hey, I'm Mr. Walker, here's my case. They're going to know about it because we contact them. So don't forget to do it. Otherwise, they're going to send me information saying Mr. Walker never even showed up. Okay?
Okay.
Do you have any questions about anything else, Mr. Walker?
No. So they'll let me know about the family violent class.
So when you meet with misdemeanor probation, they'll see what your conditions are and say, hey, family violence intervention, here's how you sign up. And they'll give you information about that.
Okay.
Okay? Ms. Beza, anything else on behalf of the state?
No, Your Honor.
Mr. Alberga?
Nothing else, Judge.
All right. Thank you, all of you, for your work on this case. Mr.
Maybe-
Walker, you are free to go.
All right. Thank you.
Thank
Your
you, Judge.
All right.
Thank you, Your Honor.
Mr. Lars, you are here for what?
Judge, I have a request for Eugenio Herrera Ramirez.
Is he here?
I don't know.
He's not. Uh-oh.
That was the one that we,
Where we got the waiver. We, 1 second.
May I be excused, Judge?
Yes, sir.
Thank you.
Someone was just asking about Ms. Beza. We did need something for Mr. Galindo. Then his lawyer waived his presence today and signed some paperwork. So I apologize. We didn't catch that earlier. I'll sign whatever I need to sign and you are free to go.
okay, well, let me too.
Oh, you got it? Thank you. Thank you. Good to see you. Take care. Ms. Woods, we are ready for whatever you've got next. We've got Mr. Lavender, we've got Mr. Peters, we've got Mr. Swanson.
Yes.
Whatever you want to do with,
Is Mr. Ringer on? Oh, there he is. Okay.
is he?
Yes, ma'am. I'm here.
Oh, there's Mr. Ringer, and we got Mr.
Hey,
Ringer.
how you doing, Judge? How you doing?
I'm doing okay. Thanks for joining us.
Yes, sir.
You have video?
Yes, I have video. I've been here the whole time, so
Okay, we'll turn on your video.
for sure. Hold up, I got my iPhone with us.
I don't know what we're doing now.
Judge, it's a waiver, but do I need to fill it out and sign on his behalf if it's a not guilty?
There's a waiver form,
Okay.
and you do fill it out. It's not so much you're signing on his behalf as you are signing as his lawyer, the waiver. So is that for Mr. Ringer?
Yes, Judge, we had this conversation over the phone last week.
Okay.
So that's what we will be doing. Although I just do need to confirm, Mr. Ringer, if you have a good address on file. Did you receive notice of today in the mail?
Yes, at 2616 Sylvan Road. Yes, I do.
Okay.
I'm looking it up while we're
Thank you, Judge.
talking. Mr. Ringer. 2616 Sylvan Road. That's you, Mr. Ringer?
Yes, sir.
Great. You will continue to get things in the mail, but your lawyer will be letting you know what's going on as well. So, Mr. Ringer, Ms. Wood's is going to waive arraignment on your behalf. This just means I don't read your formal charges to you. That will allow me to enter a scheduling order that will let the state know when they need to get discovery to your lawyer so she can share it with you. It'll have a motions deadline, and it'll just move your case along. If you have any questions about what's going on in the case, reach out to Ms. Woods. She can let you know what is happening. Okay?
Yes, sir.
You are on bond. Assuming you want to stay on bond, make sure that you continue to comply with it. I'm looking at the bond order right now that Judge Rickman entered, and you are not supposed to have any contact. This is interesting. Your bond says you are supposed to stay away from 2616 Sylvan Road.
Yes, sir. That's my grandmother's house. I do not live there anymore. So
Okay. But she'll get mail and she'll let you know, hey, Mr. Ringer, you have a court date.
yes, my mother does it too. So my mother goes over there and checks it too. She sent me a picture of it like a week ago.
Okay.
Every time I get mail over there, she either sends a picture or tells me I have to come pick it up.
If that works for you, that's fine. You just need to understand that if for some reason your mom or your grandmother dropped the ball on that, it's going to be your problem and not their problem.
Oh yeah, I don't go over there necessarily. I don't go over there. I have no contact with my uncle, and I don't go to my grandmother's house. I probably like pull down the street to the Walmart or something. They meet me there, but I don't go to the house.
Corey Vaughn is your uncle?
Yes.
Okay, good. So just keep up those conditions of the bond, and you'll get notice when you next need to come to court. And as I said, if you're wondering what's going on with my case, you reach out to Ms. Wood. She'll let you know, okay?
Okay.
All right, Ms. Wood, do you need anything?
This is right here.
All right, do you need anything else from Mr. Ringer?
No, Judge, thank you.
All right, thank you. You're free to go, Mr. Ringer.
Thank you. You have a nice one, sir.
You
You too,
too.
Ms. Wood.
Thank you.
All right, that's Mr. Ringer.
Same
What-
announcement for position 3, Dwayne Lavender.
Okay,
Mr. Lavender.
Mr. Lavender, let me see what's going on with your case. Oh, so this is old. I mean, it's a new indictment, but these charges are ancient. So you do have a bond, but my gosh, who knows? Let's find a better bond. Looks like a pretty standard bond. Okay. It keeps changing. Make sure we've got a good address for you. I've got a 2925 Diana Drive. Not good anymore. So let's do it. You got to change the address?
We've
Perfect.
updated it.
Okay. So your attorney is waiving your indictment. All that means is I don't read your charges out in the open here. The prosecutor, Ms. Hall, will get discovery to, is this going to be your case, Ms. Hall?
This is Mr. Patel's case.
Okay.
And if necessary, I'll be signing the indictment.
Not necessary. Thank you. A different prosecutor than someone in this courtroom will be getting your lawyer all the discovery, and you and she will talk about it. And then Ms. Wood will decide if she's filing any motions on your behalf. If so, we'll have that hearing. If not, then we'll get you ready for a trial. And this case from 2017 will move its way along. All right. Anything else for Mr. Lavender?
No, Your Honor.
All right. As long as you get those forms to Ms. Nelson, we'll get the address updated and scheduling order out.
Okay, perfect. So you're good to go.
I
I've
appreciate
got your
you.
number. I'll be in touch, okay?
Okay.
All right, have a good day.
All right, Mr. Peters.
Yes. Well, Mr. Peters, same announcement, Judge.
All right. So you've got a bond, Mr. Peters. Says you are not supposed to have violent contact with Simone Sharp. I don't know who that is. Do you know who that is?
Who, me?
You do?
Yeah.
Good, okay. And for an address, we've got 415 Lindsay Drive. Is that a good address?
Yes, sir.
We're all set. So your lawyer's waiving arraignment. You'll get notice for your next court date, but you should also keep Ms. Wood posted if you're moving or anything like that.
Okay.
Any questions?
No, sir.
All right.
All right, you're free to go. Have a good day. You're welcome.
So I think that leaves just Mr. Swanson.
Yes, Judge.
Is that still a plea?
Yes, Judge.
All right, we will take that. And then all that remains is Mr. Hilliard. Mr. Webb, do you need a chance to talk with your client or are you good?
Your Honor, I need to go down to the clerk's office to pull the actual clerk's file.
Okay.
Because there's a transcript in there that I need to get a copy of.
Okay.
For purposes of it.
Now's a good time to do it.
Okay, thank you.
All right, Ms. Hall, are you ready to go forward with position 7?
Yeah, I will be, Your Honor.
Okay.
Yeah, so the way it is, I didn't realize there's 5 years. Yeah, okay.
All right, I've got the Swanson paperwork I need. Are you good to go?
I am.
All right, let's get on the record. So this is position 7, 21 SC 178270, state versus, is it pronounced McHale?
Okay, yes, sir.
McHale Swanson. Ms. Hall is here for the state. Ms. Woods is here representing Mr. Swanson. Mr. Swanson, are you ready to go forward with a plea in your case?
Yes, sir.
For that to happen, you need to be put under oath, which Ms. Hall will do in just a moment. Once you're under oath, it's important that you answer her questions and mine truthfully and completely. It is no less important that you let your lawyer or me know if you have questions of your own. Mostly information will be coming from you to me, but if you have got a question or something doesn't make sense, it's not going the way you thought it was, we need to take a break so you and your lawyer can talk, that is fine. You just need to let me know, okay?
Yes, sir.
All right, Ms. Hall?
Thank you. Ms. Swanson, please raise your right hand. Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may go ahead. Please state your true, correct, and legal name.
Mikhail Jaquay Swanson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
26 and I graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 2 counts of aggravated assault with a deadly weapon and 2 counts of possession of firearm during the commission of a felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So waived.
Do you waive moving forward on a copy of the indictment?
So waived.
Mr. Swanson, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges.
Yes, ma'am.
Do you or your attorney know of any outstanding warrants related to these charges?
He has a traffic ticket and DeKalb, but I explained to
No.
him.
No, it's in College Park.
Oh, my bad. But yes, he,
But nothing related to these
nothing
charges?
related to this, but that's what he's pausing about.
Okay. Mr. Swanson, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
Minimum maximum for the aggravated assault is 1 to 20 years, and the maximum for the possession of firearm during the commission of a felony is 5 years to serve consecutive to any other count.
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for the aggravated assault, 2 years probation, and then 5 years suspended for the possession of firearm during the commission of a felony. But the court does not have to accept that recommendation. The court can sentence you to, the court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another.
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of your guilty plea conviction, just as there would be following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The
Yes,
right,
ma'am.
I'm gonna give you, no, you're fine, you're fine. I'm gonna give you a list of things that you're giving up and you can answer at the end.
Okay.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compare the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 21 SC 178270, how do you plead to 2 counts of aggravated assault with a deadly weapon and 2 counts of possession of firearm during the commission of a felony?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It's freely. I mean,
You're doing it voluntarily?
oh, yes, yes, I'm sorry.
No, you're fine. Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have, I'm sorry, go ahead.
You have any questions about that?
What do you mean limited to?
You have 30 days from today to file an appeal to challenge this guilty plea
Okay,
conviction.
no, okay, I understand.
It's limited in 2 ways. One, there's a time limit. If you decide in 6 months, I don't like what happened here, it's pretty hard to appeal
Okay,
after 30 days runs. The other limitation is because you're pleading guilty, you're giving up all those rights you heard about. And so you couldn't appeal, I didn't get a trial. Well,
Okay.
that's because you waived that right. So you'd be appealing very few things that go on here, like my lawyer didn't explain to me what the maximum sentence was, but I just heard Ms. Hall explain what the maximum sentence is. So those are the limitations. It's nothing out of the ordinary for a plea.
okay, I understand that. Thank you.
And the last question, do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I understand.
Thank you. Your Honor, the state is unaware of any prior convictions by the defendant. And had this case proceeded to trial, the state would have proven that on April the 15th, 2021, at 178 Maury Avenue, that's Moury Avenue, Atlanta, Georgia, apartment 3910. The defendant showed up to this residence, which was the residence of his ex-girlfriend, Miss Stevens. He brandished a firearm and demanded $1,500 from the victim. The victim stated to officers that the defendant was upset that she had moved on to a new boyfriend. So for that, he wanted all the money back that he contributed in their relationship at some point. They have been dating since high school off and on, but had been split up at that point for over a year. She also reported that 2 days prior to that, while she was sitting in traffic with her boyfriend, Mr. Woody, that the defendant showed up in another car and pointed the firearm at them at that point. I'm trying to think. The identification of the defendant was provided by Ms. Stevens, and he was picked up by officers and transported to Fulton County Jail. I have spoken with both victims, Ms. Stevens and Mr. Woody. And neither are scared at this point of the defendant. They do still live in the same residence, and they wanted to.
Meaning Mr. Woody lives with Ms. Stevens at the Maury Avenue apartment?
Yes.
Okay.
And they live together, and they just want to assure that Mr. Swanson leave them alone. I did confirm that he has not made contact with either victim since this incident happened, by phone call, by going over there, or any of that. So they both was opposed to actual prison time, but wanted some type of consequence. So that's how we ended up here. They
were not saying there was no gun, unlike our previous case. They're simply saying, look, he don't need to go to prison for this, but he certainly needs to leave us alone.
Right. And that is all from the state, Your Honor.
Okay.
And then, I'm sorry, I wanted to add a condition that the defendant make no contact with both victims.
Got it.
Or either victim.
Yep. Ms. Montgomery, do you have any criminal history information for Mr. Swanson?
No, Your Honor.
Thank you. Ms. Wood?
Thank you, Judge. Mr. Swanson is 26 years old. He's a lifelong resident of the Atlanta area. His entire family lives here. He currently lives in College Park with his grandparents. He is a high school graduate. He's gainfully employed right now with his father's company, A&M Hauling. However, he recently completed his training and certification for HVAC work. He's actually headed to a job fair when we wrap up here today to look for a job in the HVAC industry. He has been forthcoming with me from the very beginning, ready to resolve this, put this behind him. We're asking that you accept this plea and sentence him under the First Offender Act so that he'll have the best chance of moving forward. Thank you, Judge.
All right. Mr. Swanson, you and Ms. Stevens had been a couple, an item, it sounds like for a bunch of years.
Yeah, but it wasn't, I'm sorry. Well, okay, yes. Oh, I was gonna say that it was off and on.
Sure.
And the last time, like, we wasn't together. It's just, we were still messing around while she was with
Mr. Woody.
Yeah, so it just all came out and, I didn't understand why she would do it, but I guess she didn't want to get caught up at that time. And I loaned her some money and she was supposed to pay back, and then, it just went from there. But
Is Mr. Woody someone you know outside of knowing Ms. Stevens, or the only way you know him is because he's
the incident that happened, I never met him then,
Okay.
before.
got it? And Maury Avenue is in Atlanta. It's not in College Park.
No, it's in Atlanta.
Okay, what's the name of the apartment complex?
I think it's called the New Carver Homes.
Okay. Any reason that you need to be over there for work or anything like that?
No.
What does A&H Hauling
It's
do?
my dad's company. We contract with different companies, pick up like doors from Home Depot and deliver them. But we don't do anything like in that metro area. It's a lot of contracts. It'd be like Rome, and we go outside of the city guidelines and stuff like that.
Okay.
Peachtree City and things like that.
Any reason you need to be in Atlanta?
No, well, my mom, she stays in Lakewood, but she actually moving next month to Gwinnett. So other than that, I don't have no reason to be over there.
Do you have any kids?
No kids.
Okay. Anything you want to add about the situation?
I mean, only thing that I know, I didn't have a weapon, but that's the only thing. Other than that,
It's a he said, she said,
Yeah.
except it's a he said, they said.
yeah.
2-on-1. Okay. All right. I need to talk to you real briefly about first offender. I know Ms. Hall covered this, but you and I need to have the conversation as well. First offender is primarily an opportunity for someone who has no criminal history. That describes you. The opportunity is that even though I'm about to sentence you, if I accept your plea, to several years of probation, that's not a conviction. So if you're looking for a job at this job fair and someone from Fred's HVAC says, Mr. Swanson, you're the guy. Oh, I need you to fill out this application. And the first question on the application after name and address is, have you ever been convicted of a felony? The honest answer, the legally correct answer is, no, I have not. If you are a first offender. And as long as you're doing fine as a first offender, the answer continues to be no. And at the end of your sentence, the charges, it's not that they're dismissed, but you never had a conviction and the case is closed out. That's the benefit. And that will be a big benefit for you as you're trying to move on in life. Here's the risk. If we fast forward 6 months and for whatever reason you and Ms. Stevens started talking again, and then Mr. Woody shows up and you get mad, let's say you just have a baseball bat. Doesn't have to be a gun.
Yes, sir.
And you say, I'm going to take you both out. And she records it on her phone. And I watched that video. Not only do you have new charges, but you run the risk of having your first offender status taken away. And if that goes away, I get to resentence you. And what I might be thinking is, gosh, Mr. Swanson said it was all a big misunderstanding. I'm not that kind of guy. And here we are 6 months from now, and you're that kind of guy again. I could sentence you up to 40 years in prison, 20 for each aggravated assault. That's the maximum. I'm not saying I'd do that unless what you did was pretty darn serious. If you shot at someone, then we know what Mr. Swanson is really like. That's the downside. If you know you're not going to get in trouble, it's not much of a downside, but I need to make sure you understand that if you violate your first offender probation in a substantive way, new charges, then not only can I take away your first offender status, but without a trial, because you've already pled guilty, I can resentence you up to the maximum, which again, in this case, would be 40 years, 20 plus 20 for the 2 aggravated assaults, and then another 10, 5 plus 5, for those 2 gun counts.
Okay.
Do you understand that?
Yes, sir.
So there's a big downside, but it's manageable if you think you're going to be having no problem staying out of trouble.
Yeah, I will have no problem.
All right. Understanding the benefit and the risk of first offender, do you want to be sentenced as a first offender?
Yes.
Okay.
Yes.
Then I will do that. So I'm going to accept your plea, Mr. Swanson. I find that there's a factual basis. If Ms. Stevens came into court and Mr. Woody, and they testified consistent with what they've told the state, a jury could choose to believe them over you. You're all busted up because Ms. Stevens has jilted you, and so you pulled a gun on them. That's the storyline, and the jury could choose to believe that. They might not, but they could, and so there's a factual basis. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've been talking about, and if you didn't, I saw what you did. You look over to your lawyer, and you guys sort of nod and this and that. Do you have any questions about anything?
No, sir.
Voluntary means no one's forcing you to enter this plea. They haven't promised you anything other than a negotiated resolution. Is that correct?
Yes, sir. That's correct.
Then I accept your plea. I'm sentencing you under the Probation Options Management Act. And all that means is that if you have a small, what we call a technical violation while you're on probation, so you test positive for marijuana, you and probation work that out. I don't need to see you. We don't need to work through it.
Okay.
But if it's a more meaningful violation, you get arrested again or something like that, we get back together and we figure out what the consequences are.
Yes, sir.
I will follow the negotiated resolution and sentence you on count 1 to 2 years. Those 2 years will be served on probation.
Yes, sir.
Count 3 will run concurrently at the same time with count 1, 2 years probated. And then count 2 and 4 will both be 5 years suspended. They will both run consecutive to count 1, but concurrently with each other. So it's a total sentence of 7 years, 2 on probation, 5 suspended.
Okay.
The only difference between those 2 sets of years is that while you're on probation, you have to report, you pay a fee, et cetera, et cetera.
Cool.
Suspended, you're still under sentence. And so if we were to fast forward 3 years from now, you're done with probation, you're still in that suspended sentence window. If you go rob a bank, Ms. Hall could say, Judge, bank robbery, let's get them back in here, revoke first offender, 40 years. So your sentence isn't over until 7 years. It's just those final 5 years, you're not checking in with probation. You're just doing the right thing, working, having a family, doing whatever it is you choose to do. But I need you to understand that just because probation ends doesn't mean your sentence is necessarily over. You just don't have any responsibilities. Special condition number 1 of your sentence, and that is to stay away, have no contact with Quintori, Quentori Stevens, and that's a PH, Stevens. No contact with her. You don't call her, you don't write her. Don't put something on her Facebook page, even if it's to say, hey, I miss you, something that you might think is innocuous. That's contact. Don't do it. Same with Yandon, Yandon, Yandon Woody, ending in IE. No contact with him. So you just leave them alone. And for now, that means you stay away from that apartment complex, the New Carver Homes. It sounds like they're still living there. So if for some reason you got a new gig with an HVAC company and they say, hey, great opportunity, you're going to be doing HVAC work at New Carver Homes. There are 50 units we're refurbishing. You got to break the news to your boss. No can do. Send me to old Carver Homes. Can't go to the New Carver Homes. You need to understand that even though you don't have a conviction, while you are a first offender probationer, you cannot have a gun. So whether you had a gun or not this past April, you may not have one while you're under this sentence. If you do, and you get arrested, there's a whole bonus crime you just walked yourself into. Okay?
Gotcha.
Ms. Hall, anything else in Mr. Swanson's case?
Nothing further from the state, Your Honor.
Do one of you have the plea sheet?
I do.
There's a form you filled out, Mr. Swanson, where you initialed all sorts of things about your rights. Did you sign that form?
Yes, sir, I did.
Did you sign it after you had a chance to have Ms. Wood explain to you anything and everything in that form?
Yes, sir, I did. Yes, sir.
Any questions about that form?
Well, my mom wanted to see, can she get a copy?
It'll be part of the docket, so the
Okay,
answer
okay.
is yes.
Okay.
Any questions about the content of the document?
No,
You're good.
Thank you.
All right, Ms. Wood, you signed the form as well after you explained it to Mr. Swanson.
Yes, Judge.
Great, so I'm going to follow that. It'll be part of the docket. You can get it.
Okay.
And then the last thing, your indictment, we have a digital version of it rather than handing around paper. Do you authorize me, Mr. Swanson, to sign the indictment on your behalf indicating your guilty plea?
Yes, Your Honor, I do.
All right, Ms. Wood?
Yes, Judge.
And Ms. Hall?
Yes, Your Honor.
All right, Ms. Hall, anything else in Mr. Swanson's case?
Nothing further from the state.
Ms. Wood?
No, Your Honor.
All right, Mr. Swanson, you're done.
I got a question.
Yes, sir.
Are you going to explain like when I start probation or?
Oh, right, we're not done. Listen closely. Ms. Montgomery has one more roll before she's done for the day.
Good job.
Ms. Montgomery, will you please share with Mr. Swanson and his attorney his reporting instructions?
Absolutely. Mr. Swanson, what county do you stay in?
I stay in College Park. I mean, Fulton County,
Fulton.
but yeah, sorry.
No, you're fine. I'm gonna have you to report on the 19th of August to 276 Memorial Drive, Southwest Atlanta, 30303. Ms. Wood, I sent you an email asking for his phone number and address.
Okay.
And I will also, once I complete the reporting instructions, I will forward it to you and also his email address so I can send it to him as well.
Perfect. I will get that to you.
Thank you so much.
I got one question.
Sure.
Will you be my probation officer or I will meet them when I get there?
You will meet them once you go into intake.
Okay, thank you.
At 8:30,
8:30 in the morning?
Here, I'm put it right here.
Okay,
the 19th, I'm sorry.
okay,
Yeah, and I'll get it to you in a more formal way
Okay.
too.
thank you.
You're welcome.
All right. Ms. Patel, you're back. Are you helping out with the Hilliard case?
Oh, no.
Okay, you're good to go.
Okay, thank you, Your Honor.
But he waived arraignment.
Oh, yes. Sorry.
So I appreciate you coming back, but he's already left, waived arraignment. We'll get a scheduling order out and you'll get discovery to Ms. Wood.
Sounds good. Thank you. Sorry to step up.
Not a problem. Good to see you.
Good to see you. How are you?
I'm well. Yourself?
Doing well.
Adjusting to life as mom?
Yes, it's good. I hope he'll start sleeping more, but.
Good luck with that.
Around the corner.
Definitely by age 4.
Oh, my goodness. Judge, may I be excused?
Yes, ma'am. Thank you for all your work today.
Thank you. Happy to be here. It's my first day with y'all.
Is it the first full day?
Yay.
Excellent.
So excited.
So it looks like maybe Friday, I will see you with the other Ms. Patel.
Correct.
Randy Manuel is first or second out
Yeah.
the following week. So if the plea doesn't go through, we'll see what happens. But fingers crossed.
Your Honor,
Hold on 1 second. Yes, Ms. Nelson. I'll get that to you in just a second. Yes, Ms. Beza. I thought you had already gone to Judge
I
Millender.
did. I was looking for Miss Shaima Patel. We wanted to speak with you about a case. I didn't know if she was in the courtroom. She told me to log back in if I finished there early, but it doesn't appear
Okay.
that she's there.
She was on briefly, but to allow Ms. Primovic to be on, so she is no longer here. We're going to shift to a hearing now, but if you can get Ms. Patel, we can always connect. We could talk on the phone if we need to, or whatever works. What's the case?
The case is Michael Robinson,
Is he on the
August 16th trial calendar.
Great. Look forward to talking to you guys about it.
Thank you. Bye.
All right. Take care. All right, Ms. Montgomery, you are free to go. Mr. Hilliard is not going to be entering a plea today, so you're welcome to listen to the hearing in his case, but if you've got other things you need to do, that is fine. Thank you for your help.
Thank you so much. You guys have a great day and stay safe.
All right, we'll do. Ms. Hall, are you planning on having anyone appear remotely?
No.
Okay, Mr. Webb?
No, Your Honor.
Okay, I don't think we need to keep Zoom up and running unless they're going to be exhibits that anyone is going to be sharing that you need to be up on a screen. Well, I'll just leave it going. That's fine, but.
I'm gonna do the video, but do you want us to do it through Zoom?
Yeah, so we'll leave this up. All right. Ms. Rivers, do you need a break before we turn to Mr. Hilliard's case? Okay. All right. If during the course of it you need one, let me know. Mr. Webb, I know you were racing down to the clerk's office. Did you want to speak with did you want a chance to speak to Mr. Hilliard before he comes out and we engage?
No, Your Honor. I went to the gym.
Okay, great. Are you ready for him to come on out, or do you want a couple minutes?
He can come on now.
Okay. When you all are ready, we can bring Mr. Hilliard out.
When did you file this?
Nothing, they sent this to me from here. Nothing, I called you.
I'm sorry to answer your question. You on the Swanson case?
2 years is certain probation, 5 years is suspended.
Suspended for,
5 years is suspended.
no, just it's suspended consecutive. So 3, 2, and 4 run concurrently with each other, consecutive to 1, and 3 is concurrent with 1. That makes sense? But what I did was 1 and 3 first. I said it's 2 years to serve on probation, both those. Right. Yeah, and then consecutive. So it's a total sentence of 7 years.
I just was.
Yeah, suspended. All right, let's go on the record. The first question I had, well, first of all, it's indictment 17 SC 152402. Sir, how many letter I's are there in your last name?
It's 2.
So it's Hilliard.
No, it's like, it's Hilliard.
Okay, but it's Hilliard.
Yeah,
Hilliard, okay. I've seen it both ways, Hilliard and Hillard, and I just wanted to get it right.
thank you.
All right, so we're here on the case of State versus Hilliard, 17 SC 152402. Mr. Webb is representing Mr. Hilliard. We've got Ms. Hall and Mr. Armstrong here on behalf of the state. And it would help me if we could talk at a high level about what we're going to cover today. I have 3 motions from Mr. Webb. One is a constitutional speedy. I know we're covering that today, or at least the state's prepared to do that. Hopefully Mr. Webb is. I've got a motion that is simply entitled motion to suppress. And I'm going to have Mr. Webb articulate what specifically he's trying to suppress in that. It sounds like identification, but I want to make sure we're covering what he intends us to cover. And then there is a third motion to suppress what are characterized as unlawfully obtained statements. And it relates to interaction Mr. Hilliard had with Pennsylvania law enforcement. But that may not be all of it. There was apparently also the FBI that got into the mix. And so I just want to make sure we're being as inclusive as necessary so that if I deny the motion for constitutional speedy violation and we tee this up for trial, we don't on the eve of trial learn, oh, wait, I don't want the statements of the FBI to come in either. So, Mr. Webb, first things first, you're prepared to go forward on the speedy trial motion.
Your Honor, I'm prepared to go forward on the notice of discovery deficiency because I need some of the things that are outstanding in order to argue the other motions.
Okay, well, that's a good place to start. You need things that you believe the state has and has not provided in order to argue the speedy trial motion?
No, not that.
Okay, so my question was, can we cover the speedy trial motion today?
The speedy trial motion, I was going downstairs to get the transcript from the bond hearing. I need that transcript and it hasn't been filed yet.
Okay, well, I think what we'll do is argue some about this and you can tell me where there's a placeholder for the bond hearing transcript. And if we need to supplement the record, we'll be sure to do that.
Your Honor, if I may, it is my understanding from Ms. Hall that this case has been brought back through the Interstate detainer process, which means that there is a limited number of days.
Oh.
And so if things can't happen today, we ask that there be a specifically set number of days continuance that do not affect that calculation.
So Mr. Hilliard is still serving time in Pennsylvania and we borrowed him?
That is my understanding at this moment, but I can check to ensure that.
Okay. Well, why don't you, my understanding was that he finished his sentence in Pennsylvania. There was a hold on him from here. And so instead of walking out of the Alatoona State Penitentiary, a free man, he was put on a bus and brought down here because he's got these charges in Fulton. That
is probably the case. But I think he filled out paperwork that made it look like he was doing an interstate detainer, which has a date deadline. Whereas if he was just held by our detainer and brought to here, there wouldn't be a deadline. But he filed up paperwork, or Ohio put the wrong paperwork in to make it look like it was we're borrowing him. And so I just want to make sure that if that's the case, that we don't lose out by a continuance.
Got it. All right. Let's get that clear as well.
Oh, it was on when I was talking.
Yeah, he turned it off.
I turned it off after I stopped, so there wouldn't be like too much noise going on if that happens. I'll also try and speak more directly into it. Does this move? No.
So I'm not seeing anything in the docket, but there's an older case. Of all the detention stuff?
This is, I'm approaching Ms. Nelson with what the state has in its possession. This is our only copy of the moment.
Ohio. I don't know why I said Pennsylvania. Maybe that's just where he got arrested at some point.
Yes. He
Okay.
came from Pennsylvania to Georgia, committed the crimes here allegedly, and then went to a different, to Ohio and was arrested there.
Okay. So the bond hearing you're interested in, Mr. Webb, would be way back in 2017. And so I need to look in the docket for the older indictment. It's got it, because bond isn't an issue right now. I mean, this is all interstate detainer. Okay. Right. So you've been representing Mr. Hilliard since the get-go. I mean, I've got a motion to substitute counsel back in July of 2017. You've been on this case.
Since May of 2017.
Got it. You filed a statutory speedy trial demand in May of 2017. Judge Downs denied bond in April of 2017, and that's
when she gave us the right to file the speedy.
Out of time.
Correct.
Your Honor, I'm a little bit confused by that because Mr. Webb didn't enter his appearance until after that point in time. Until after that bond hearing. His demand for speedy trial is hand dated May 18th, 2017. And his, I believe May 9th was his entry of appearance along with all of the motions that he filed along with his entry. And the speedy trial, the demand for speedy trial is filed on the date of a case management hearing that Judge Downs had, but there's no document entering any order giving people permission to file an out-of-time speedy trial demand.
Right. So what I'm hearing, gosh, this is actually, there were 3 indictments.
Well, I believe the first indictment was for a different defendant. And so I think Hilliard, only has 2 indictments, I believe, Your Honor.
He was added with the one ending in 465. And that in turn was superseded, since we're not allowed to just call something a superseding indictment. It gets a new number, creating all this confusion. The one ending in 402. That's what we're moving forward on. Okay.
Yeah.
All right, let's get back to where I was. we're going to need to talk about the constitutional speedy. We've got the motion to suppress that is focused on some aspect of, I think, identification of your client. It's just entitled motion to suppress. Is that something that you are able to go forward with today, Mr. Webb, or this is where we need to talk about missing discovery?
That's where the missing discovery is.
Okay, and what about your third motion, the unlawfully obtained statements motion?
That's the officer from Pennsylvania.
I agree, but is that one we can go forward on?
Yeah.
You can go, I don't know if the state can, but that's the state's issue, not yours. You're prepared to go forward with constitutional speedy as well as unlawfully obtained statements. And then you're going to tell me why we can't go forward on the identification in a minute, once I get the docket for the newest old indictment up.
Your Honor, Ms. Hall will be handling the two latter motions. But there's just one thing that I wanted to say about the motion for which there is a discovery issue, not about a discovery, but Your Honor has a standing criminal motions order that is online under fultoncourt.org. And in it, it talks about each motion shall be limited to a single issue, e.g. suppression of statements, suppression of fruits and search warrant, et cetera. Multi-issue motions seeking to suppress, for example, both physical evidence and statements are not proper. In this vein, motions must specify with particularity, and it goes on. And so if his motion seeks to suppress anything other than the identification, we would object to that being filed in this manner because it's not clear from the motion, and Ms. Hall wouldn't have those witnesses here. But it factually might not be important because we believe the search that they're talking about that had physical evidence preceded the identification, so it would not, the identification wouldn't have led to that search.
Okay.
But I just wanted to make that clear because of the general order that's online.
Okay, well, I'm going to have Mr. Webb unpackage the one that's entitled motion to suppress in a minute. I'm just reading through the notice of discovery deficiency, which was filed, also consistent with my standing order. So, Mr. Webb, in your notice of discovery deficiency, as I understand it, you are claiming that you lack three things. There may be more in number, but it's three categories. Original photographic lineups, you've got a plural, and then audio recordings of the alleged victims and video recordings. And that latter two may be one and the same. It may be that the recordings have both audio and video, but what I'm understanding is that you're saying whatever statements were taken from the alleged victims, you don't have them other than maybe a written synopsis. Is that a correct?
That's correct.
Okay, so let's start there. Ms. Hall, are there photographic lineups in this case?
Yeah, yeah,
Okay, and do you have the originals?
I do.
Okay, so Mr. Webb can see those originals.
Yes, and he has a copy of them.
Okay, when did he get the copies of the photographic lineups?
In 2017.
Okay,
Again, in May the 28th of this year, and then again on Friday, the 31st, I believe.
okay. And what you understood, I know it wasn't your case back in 2017, but what you understood to have been provided in 2017 is the same thing that you would have provided in May of this year and that you provided again just this past Friday.
Yes, sir.
Okay. And what about audio and or video recordings of statements from the alleged victims in this case?
The same answer, Your Honor, that was provided.
They exist and they have been provided now 3 times. Okay. Mr. Webb, we're having a disconnect here. Tell me what it is you don't think you have, and also tell me why you what you've been given now 3 times isn't what you're asking for.
There are 3 alleged victims in this case, Your Honor. The first victim is Brad Thomas.
Brad Thomas.
Yes. In the discovery that's been provided, they indicated that they spoke to Brad Thomas. They went to the hospital to interview Brad Thomas. No statements have been provided whatsoever. No videotatements, no audio statements. So if there are video and audio of Brad Thomas, I would like to see them from the state today.
So you did receive some statements of alleged victims, but nothing from Brad Thomas that you've been able to find or play.
Correct.
Okay.
The second is Damian Sanders. Damian Sanders was another person who was involved in this case.
Involved on the victim side of the ledger?
The alleged victim.
Okay. We say alleged victim, I assume people got shot. This is what it's about. So
Damian Sanders is the one that got shot.
Okay.
And Brad Thomas.
What about Damian Sanders?
Damian Sanders, the state provided to me a audio and a video. However, it's not complete because there are parts of it missing. And I brought that to Ms. Hall's attention regarding the, it's 3 actual videos. Video CD1, CD2, and CD3 should be, but I don't have CD3. And the discovery that they provided only gives 1 and 2.
Have you watched what's on 1 and 2?
Yes, that's why I know that there's another part that's missing because of what's in the actual report.
So if I were to watch 1 would end with your client's, no, not your client, Mr. Sanders saying something, we'll pretend mid-sentence, and then 2 picks up with wherever he was. And then CD2 ends with Mr. Sanders or a detective in mid-sentence, and you don't know where it goes from there, and that's CD3.
Correct.
Okay.
And then on the third alleged victim, Amir White, the state provided me a disc, but it's of a rape. It's not of Amir White.
Meaning you play the video and there's someone talking, but that person's talking about being the victim of a rape.
Correct.
Is it a female?
It's 3 guys.
3 guys are being interviewed at once?
3 guys are being interviewed on that particular CD for Amir White.
Okay.
They say it's the CD of Amir White, but when you play it, it's 3 separate guys talking about a female that's been raped.
Got it. So it's not 3 guys at once. It's 3 different interviews, none of whom is Amir White. Maybe they're all Amir White. Amir White's not talking about being shot at the dollhouse.
Correct.
Okay. Okay. And would Ms. Hall be correct if she were to say, I've never heard those claims from Mr. Webb that Amir White, it's the wrong CD and I don't have the 3rd CD for Damian
I
Sanders?
told them that I didn't have it and still have not gotten it.
Okay. All right. What about the lineups?
The lineups, what they gave me, and I can show the court what they gave me, 6 people were shown photo lineups. So in essence, there should be 6 different lineups. What I was given is some black and white photos.
You believe that there were 6 witnesses showing photo lineups because police reports talk about, we showed it to this guy and this gal and this guy, and you count 6 people
Right.
who, according to police reports, were allegedly shown photos or photo lineups.
Correct.
Okay. And you don't have a way of saying, this is the lineup that was shown to Fred Smith, this was the lineup that was shown to John Richardson.
Right.
Okay. All right. So Ms. Hall, let's start with the witness statement, the victim statements. Brad Thomas. Mr. Webb is saying, I got nothing on Brad Thomas. Do you have anything from Brad Thomas? And Mr. Either one of you can answer. I just need the state to explain what's going on with Brad Thomas's statements.
One of the things that just caught my attention, when we were in the back, I was writing notes, and the question was, in a report, Mr. Webb indicated that somebody indicated they were going to interview this person. And his question was this person ever interviewed? And so he didn't identify a police report that said he was interviewed. And so I just wanted to mention that part because as far as the state's concerned, everything we have, we've given over. And so we'll go look for things that we know are out there if they're in the custody of the police. But as of 10 minutes ago, it was that interview, was he interviewed?
Okay. And we don't know the answer to that. It's knowable. I assume you can talk with the lead detective. He or she can look at the file. But what you've received, Sandy Springs is our lead agency. So Ms. Hall, what you've received from Sandy Springs in terms of digital media, apparently it doesn't include an interview of Brad Thomas. Or do you recall, oh, actually, I've watched the interview of Brad Thomas.
Well, Your Honor, I just learned about 15 years ago when we were in the back that is something that he doesn't have and thinks he doesn't have. So I don't know specifically whether we have it or insert it. If we have it, it's been served, but I don't know if it's a part of it. So I did ask the lead investigator. I actually was on the phone with him, confirming what was given, what existed and didn't exist. I missed that last question. So I did text him to confirm, but that is something I just found out that possibly is missing.
So what I understood Mr. Webb to just say was that he has been specific with you in the past, and I don't mean 10 minutes ago, but in May or last week. Ms. Hall, I don't have Brad Thomas's interview. You're disagreeing with that. You're saying, hey, Mr. Webb told me he didn't have victim statements, and so I've looked for victim statements, or which is it?
So that's untrue. I have an email from Mr. Webb that he sent to me on Friday. He listed 3 specific things that he was missing. And when I made sure that we had those things and they were served, then today he came with another list of 7 items that he was still missing. So
were any of those 7 not included in what Mr. Webb just told me he did not have? Because I don't want to have this conversation again. Is there something else he's missing?
So the things that he said he was missing, I got the lead on the phone and he confirmed that they didn't exist or where he could find them.
Okay.
In the case file, but
as in he already has it. He just, maybe he wasn't looking in the right place because it's a big case.
Right. It is a large case with a number of evidence that we have. So he directed him to where he could find that.
Great.
And Your Honor, as the issue is for the 3 videos for the 1 victim's interview.
Mr. Sanders.
It was what you had suggested before, where Ms. Hall said, when we talked about that, she indicated that he had not told her that there was a 3rd one. He mentioned that there were victim interviews. And from the conversation between the 2, it appeared that no specific number was given. So Ms. Hall was thinking it was just the victim interviews that she already had.
Got it. And so she dutifully reproduced what was provided in May of this year, but it turns out that there's a 3rd CD that, or
Potentially.
Right.
Okay, that needs to be found. And then what about Amir White? If you click on the Amir White file or open up that disk, it's 3 guys talking about an unrelated case.
For the state has the interview. The state provided the same to defense counsel. That is the evidence that we plan to present today. So
you've clicked on the Amir White interview and you've watched Amir White answer questions from Sandy Springs officers.
From Officer Sergeant Williams, yes.
Okay. And I know you often have you sometimes have support staff helping you, but your understanding is that the Amir White file that you've watched was burned to a disk or put on evidence.com or however this works and made available to Mr. Webb.
Yes, it's detailed in the certificate of service in 17. I personally copied it in May and then my legal assistant recopied Friday.
Okay. And finally, what about photo lineups?
So the photo lineups that when he said that there were 6 photo lineups, those were witnesses that were presented photo lineups to the other co-defendant, Mr. Lloyd, not pertaining to his client. However, it was still provided in the discovery and it's actually provided in the initial discovery. You know how sometimes we file, it's 547 pages and every single one is there. It is in black and white, but that is the way it was presented.
Okay.
It was never presented in color.
But maybe more importantly for my analysis, your understanding is that those 6 photo lineups or those 6 individuals were being asked to potentially identify a co-defendant, not Mr. Hilliard.
Yes, and it's my understanding there were 5 other than the White, other than my victim, Mr. White.
Amir White.
Yes.
Okay.
So there are 5 that he's referring to, and none involved his client.
Okay, but all have been included in
Yes.
some form of discovery.
Yes, sir.
You mentioned that the original discovery, and you're saying that it's probably in Odyssey because
It's 547 pages. I'm not sure if it made it to Odyssey. It includes with the certificate of service, but sometimes we'll stop what goes to Odyssey, if that makes
Okay.
sense. So
But
I'm
it
not
was-
sure if it made it to Odyssey.
Okay, but it's that initial one that has the indictment and the basic police report, and that had these lineups, a black and white copy of them, but those lineups.
Yes.
Okay, all right. So, Mr. Webb, it sounds like a couple things were maybe newly identified within a category that you've identified in the past that the state needs to close the loop on. Were there any statements from Brad Thomas? Where's that third disc from Damian Sanders? And I don't know what to tell you about Amir White. Apparently, the one you received most recently isn't the right one, but it's been sent more than once. More importantly, it exists. And so it sounds like we have to get down to the, I don't like it when it gets this way, but Ms. Hall or someone from the DA's office is going to have to give you the disc, and while you've got it, make sure you can open it and that it's the Amir White interview and not something else, but it's out there. I'm not quite sure how any of these bear on the constitutional Speedy, but I don't think you said they did. That was the bond hearing transcript, if one exists. I see maybe how the photo lineups, or I guess, did Amir White, who made an identification that you're trying to suppress, Mr. Webb?
Amir White.
Amir White. Is that the only identification you're aware of?
That's the only person who identified allegedly my client.
Okay. So the interview of Amir White included the presentation of a photo or a photo lineup, or they're two separate events? He's interviewed and then later there's a photo identification made.
He's interviewed supposedly the next day after the alleged incident. He's shown a photo lineup on that day. Then he comes back on February the 13th of 2017 and he looks at another photo lineup. And on the second time is when he allegedly identifies my client.
Okay. Is that your understanding, Ms. Hall, of the basic procedure of how Mr. White purportedly made an ID?
So I guess this goes in line with the motion where there was a one-on-one lineup presented, and that's untrue as well. The first interview that he had, or the first interview where he was showing a photo lineup, that was of the co-defendant, where he identified the co-defendant. And the second one on the 13th would have been of his client, where he again identified his client. So there was never a one-on-one, a show up, or just a one photo lineup ever presented to any of the victims to pick out any of the defendants. It was always an array of photos.
It was always an array, and the first array on, I'm going to get the date wrong, but February 13th, whenever it was of a co-defendant, not of Mr. Hilliard.
That's correct.
Okay, and then per Mr. Webb's observation, a few weeks later, Mr. White re-engages with law enforcement, showing a different lineup, and Mr. Hilliard is in that other one, and Mr. White makes his identification.
That's correct.
Okay, all right. Mr. Webb, can you distill for me, please, what it is you are trying to suppress in your motion entitled Motion to Suppress?
You came through because it didn't state specific information that wasn't known to you.
The motion to suppress that is filed with the court addresses the identification of my client.
Okay, and how many times do you believe your client was identified by someone in this case?
Once.
Once, Mr. White.
Right.
So it's what we've been talking about. All right, and you're trying to suppress that.
And then if I can see what the state said they have, then I can
Keep going.
argue that motion more intelligently.
Okay.
I want to be able to see what they're saying did not occur on their video that they said they had.
Okay, got it. So what I'd like us to do is start with the constitutional speedy. As I mentioned, Mr. Webb, I won't close the record on it so that you can try to find, once I have more context, I may not close the record if it makes sense for you to see if a transcript exists for the bond hearing that Judge Downs heard in 2017. But I need to be able to place that in the larger constellation of what I need to consider for a purported constitutional speedy violation. So let's get through that. Actually, I'm going to flip it around because we've got our sergeant here. The motion to suppress, not unlawfully obtained statements one, but motion to suppress the identification. That's what I understand it to be, and what Mr. Webb has put on the record, that motion relates exclusively to Mr. White's purported identification of Mr. Hilliard as someone involved in this shooting. We're going to hear that first so we can get the sergeant on his way. Mr. Webb, this may also be a motion where I need to keep the record open because you need time to supplement, because you're going to be reacting to something that you're learning because you didn't get something in discovery. But based on what I've heard, I think that I can receive testimony from this witness. If it needs to be supplemented, like I said, I'm comfortable leaving the record open. I'm not comfortable doing nothing on the motion today. It's the state's burden anyway, so let's see what kind of record they start to establish. And if you feel like your cross-examination is hamstrung in some way, you can let me know. And if we need to pick it up again after you get what you say you're missing, in particular, the Amir White interview. And it may be that you look at it and I look at it and we realize that doesn't shed any light on this issue because what happened on that interview was a different defendant identified in a different lineup. Okay? All right. So Ms. Hall, when you are ready, if you want to call your witness, let's take care of that.
Thank you. Your Honor, the state called Sergeant Williams to stand.
Sergeant Williams, come on up, please. And Mr. Armstrong, as you are getting ready for what you're going to have to say about the constitutional speedy, if you could let me know what your math tells you about the IAD and where we are, that would be helpful. Thank you. Sorry.
You swear to affirm that the testimony you're about to speak today is the truth, the whole truth, and nothing but the truth. I do. So you can see. State and spell your name for the record.
Jonathan Williams, JONATHAN WILLIAMS.
Good afternoon, Sergeant Williams. How you doing?
Good. How are you?
Good. Thank you for being here. Just want to first start with where you're currently employed.
The Sandy Springs Police Department.
And how long have you been employed there?
15 years.
What is your current title?
Currently, I'm a sergeant on patrol.
And what are your duties and consistency?
Now I'm a supervisor. I supervise different shifts, patrol shifts.
Back in February of 2017, what was your title?
I was a detective.
And what were some of your duties as being a detective?
I would investigate all kinds of crimes, anywhere from thefts up to murders.
Were you sometimes involved in presenting photo lineups to a suspect that didn't have anything to do with a case that you were involved in?
Yes.
Do you remember presenting a photo lineup in this current case with the defendant being Mr. Hilliard?
But very vaguely, but yes.
Okay. Do you remember, did you put together that lineup?
I did not.
Do you remember being involved in that case at all?
I was not.
Do you remember what day that photo lineup took place?
February 13th, 2017.
And can you describe to the judge, the court, the circumstances of it, the lighting, the area, the location you guys were at, if you remember?
I do. We have a couple interview rooms. They're very basic. There's a table, a couple chairs. and 2 cameras in the room. It's very basic. Both of them are the same.
Do you know the date of the incident that caused you to present that lineup?
I do not.
Would you believe me if I said it was February 6th of that year?
I would believe you, yes.
So this photo lineup happened a little bit over a week after the incident occurred. Was anyone in the room with you, anyone else in the room with you other than the victim, Mr. White, when you presented?
Just us 2.
Was it memorialized?
Yes.
Do you know if that was a audio that was taken or a video that was taken?
Video and audio.
Okay. Did you read to the victim the ammunition form?
I did.
I'm going to pause you for a second. Mr. Webb, I did not hear you say, I don't have the video of what Sergeant Williams is describing. Do you have the video and audio of Sergeant Williams' presentation of the array or photo lineup to Mr. White?
No, I don't have anything involving Mr. White, Regal White.
Okay, I thought what you didn't have was this first encounter with law enforcement when someone from Sandy Springs showed Mr. White a lineup that had a co-defendant in it. You're saying 0. You have, there's nothing you can click on and watch and listen to that's got Mr. White in it.
What I have concerning Mr. White is what's listed in the reports.
Okay.
Of what they said occurred.
Okay, meaning it's a write-up, it's a summary of what happened, but it's not the recording of what happened. Okay. But we've got the recording right here. All right.
I asked you, did you read the ammunition to the witness?
Yes, ma'am, I did.
Did you tell the witness who to pick from the array of photos?
I did not.
After you read the ammunition to the victim/witness, what did he do?
I'm sorry, after I read the admonition?
I'm sorry, I should have better framed the question.
Okay.
After you read that, did you present the lineup to him at that point?
I did, yes.
After you presented the lineup, was he able to identify a person that he thought was involved in causing him to be a victim of this case?
He was.
And did he indicate anything? Did you have him indicate which of the photos was the person that he was identifying?
Yes, he did.
And how did you have him identify that?
He wrote a percentage, and I believe he signed his initials on the actual form that I gave him with the photograph on it.
Okay. Your Honor, may I approach the witness?
Yes, ma'am.
Oh.
When you say that Mr. White gave a percentage, Sergeant, as in I'm 10% positive or 100, whatever the percentage is, was a reflection of his perceived certainty?
Yes, sir.
Okay.
That's exactly right.
Just one more question. Do you remember what percentage that was?
75, I believe, 75%.
I'm approaching the with what was previously marked as State Exhibit 1. Do you recognize that?
I do.
What is that?
That is my photo lineup admonition form. That is my signature right there. And this is the photo lineup. And that is his percentage, 75, and I believe that's his initials.
When you say he is, who are you referring to?
Mr. White.
And what you have there is that the 6 photos that you presented to Mr. White on February 13th.
It is.
And that is the ammunition that you read to him on the 13th.
It is.
Is that a true and accurate depiction of what you presented that day?
Yes, it is.
And before I take it back, I want to can you go through the photos and describe the individuals that are depicted in photos. You don't have to say big nose, small nose, but like your type, if the pictures are. I'm
Sure,
sorry.
yeah.
Before you do that, let me clarify. Are those pictures presented in black and white?
They are,
Were they presented in black and white on the day of the presentation?
they were.
Okay. Can you describe those photos?
So you have 6 different photographs. They're all fairly similar. Black males, short hair, showing teeth, that's kind of smiling. You want to have them as similar as possible. Obviously, you don't want to throw a female into a 6-person photographic lineup. So you've got to keep them as similar as possible.
Okay.
Sergeant, did you know which of the photos was the person of interest for whoever the detective was in the case?
I did not.
So I guess by reasoning then, you had no way of knowing if Mr. White had picked out what I'll say in air quotes is the right guy.
I did not.
Your Honor, the state, tender states exhibit 1 is evidence.
Mr. Webb, any objection other than, I know you have an ongoing concern about what clarity of copies, if any, you've received of these. Do you have any objection to the admission of the admonition form and the accompanying, I'm going to call it an array. When I think of lineup, I think of the 6-pack. I think this is what we more typically call an array. It's 6 separate photos, but let me be sure before I call it that. Sergeant Williams, did you have something different than what we've got here, the classic 6-pack with 6 windows in a folder?
That's what I have always done. That's what we do typically in Sandy Springs, and that is exactly the lineup that I showed Mr. White. Right?
So you call it a lineup, but you handed Mr. White 6 individual pieces of paper, each one with 1 photo.
That's correct.
Okay. All right, Mr. Webb, anything you want to get on the record in terms of objecting to the admission of States 1?
I would just basically put my ongoing objection to this particular lineup, because I think that what was provided to me is different.
Okay, I'll admit it for purposes of this hearing.
Sergeant Williams, I would like to just clarify how you actually present the
Thank you.
lineup. Do you hand all 6 photos to a witness? Do you keep them? How is it actually presented?
Well, the way I do it is I show them and I tell them before I start that I'm going to show you all 6 photographs, and I'm gonna hold them and I'll show it to you. And when you're ready to see the next photo, then I'll show you the next photo. If you pick somebody out, if it's the second picture, if you pick somebody out, I'm still going to show you all 6. And that's what we did with Mr. White, or that's what I did with Mr. White.
I'm now approaching the witness with what previously marked as States Exhibit 2.
Yeah.
Do you recognize that?
My signature.
Do you recognize what device that, or do you know what that is?
Yes.
What is it?
It's a thumb drive that we watched the video that we're speaking of today. We watched it this morning on this thumb drive.
That's the video of the photo lineup that you presented to Mr. White?
That's correct.
Is that what you watched with me? Is that a true and accurate depiction of what you presented and what happened in that room?
It is, yes.
And how do you know that that's what that is?
That's my signature. I put it on there this morning.
Your Honor, the state to admit, I'm sorry, the state would like to publish the photo lineup presentation.
Okay, so that's audio video of Sergeant Williams's interaction with Mr. White.
Yes.
So that's not in evidence yet. You want to admit it. If it's admitted, you may publish it. Mr. Webb, you've got an ongoing objection about whether you've received these things in the past, which I invite you to renew now. Anything else you want to add in terms of objecting to the admission for purposes of this hearing only, States Exhibit 2?
I would object based on the fact that I wasn't provided this particular, whatever it is that they are.
Okay, we'll see what it is. And I recognize there's a conflict between the two sides as to whether it was previously provided. I take you at your word, you've not seen this, but we are about to see it.
Thank you. And this is whenever we use the Zoom, right?
So yes, you're going to share your screen. You need to make sure that you click share audio as well. There's a little checkbox in there that doesn't jump out at you.
I'm sorry, Your Honor, can you say that one more time?
Yes, when you are doing the share screen through Zoom, it's important. There's a little checkbox in the corner about sharing audio as well. If you don't check that, we won't get a good audio feed of the video that you've got.
Okay.
You know that I'm gonna go get a computer with that block.
Okay. Your Honor, one moment, I'm pulling up the links.
Okay.
Oh, wow. Your Honor, do you think you can, my computer just died? I didn't bring my charger because I have a break in between. My apologies. Can you give me the ID? I have a second computer, but it's about to die as well, but hopefully we can make it through our presentation.
You're almost out of batteries altogether.
Yeah, Mr. Armstrong went to go get working devices.
Oh, he supports you in a variety of ways. Yes. It is.
Oh, you have it?
Oh, you got it? Okay. Whoa. Someone's sharing the screen.
Okay. Okay. Yeah, here.
So you need to mute your machine.
I thought I did. Mute my Zoom or?
Your computer, you gotta make sure there's no microphone going on your computer. There you go.
Okay, let me see. Yeah, here?
Detective Williams, I'm gonna show you the lineup. I'm not really sure what's going on with his case, so that way I can't really influence you in any way. Before I do that, I'm gonna read something to you real quick before I start, okay? I'm about to show you a group of photographs to see if you can make an identification of the person or persons who committed the crime now being investigated. This group of photographs may or may not include a photograph of the person who committed the crime. An identification if you can do so. You may not talk to anyone while viewing the photographs. Since hairstyles, beards, and mustaches are easily changed, the photographs you are viewing may not depict a hairstyle or the facial hair similar to that of the person who committed the crime. Also, note the photographs do not always depict the true complexion of a person. It may be lighter or darker than shown. Pay no attention to markings or numbers appearing in any particular photograph. Please do not discuss with other victims or witnesses whether or not you have selected a photograph during this investigation. You clear? Okay. All right. Let's see. What time you got? 2:20. Okay, if you would, if you want to read it again, you can. If not, when you're ready, just sign right there for me.
Is there any volume?
Can you turn the volume on your machine up?
Time. Okay.
It's a,
6 pictures.
it just unmuted.
The person, that's fine. I want to keep showing you the rest of it.
All right, why don't you pause it for a sec?
Ready to see the next picture.
Okay,
So when I turn the volume up on mine.
right. No, yours needs to be muted. Let me see if I can turn it on.
On the upper left corner, there's a volume on the L3. I think you got to move that up. Right there. Yep. Maybe that'll help.
I pull it back a little bit more, a little bit.
So if you find one that you think is the right person, that's fine. I want to keep showing you the rest of them, okay? So just let me know when you're ready to see the next picture, okay? Okay? Let me see that, which one? No? Can you give me a percentage of what's your percentage you think from 0 to 100?
Probably like 75.
75%? Okay. Would you write that down there for me and sign it for me, please? Here, all of it. You right-handed, don't you? Yeah. All right. All right. Give me just a second. Let me get Detective Johnson, and I'll have him come in and get you, okay? All right.
Sergeant Williams, when you left out the room at the end of that video, was that your only interaction with that witness victim, Mr. White?
I believe it was, yes.
Was there anything else that you did after you presented this lineup with Mr. White?
No.
You mentioned that Detective Johnson to Mr. White. You're gonna go talk to Detective Johnson. Is that the lead detective for the case?
Yes, sir.
Okay.
One more. Yeah, no further questions.
All right, Mr. Webb, any questions for Sergeant Williams?
Hello, Sergeant Williams. How many lineups did you show to individuals in this case?
Can't remember. I believe this was the only one.
The only one?
I believe so.
And did you introduce it into evidence?
Yes, yes, Miss Karen.
May I approach?
What do you need?
The lineup.
Yes, sir. Plaintiffs 1, states 1.
Is this the original lineup?
It looks like a photocopy.
So
Copy.
it's a copy?
That's right.
So does it change as it goes through the process with markings that are made on it?
Not that I know of.
I'm going to show you what will be marked as defense exhibit number 1.
Is this the lineup?
This is what was provided to me.
You said you didn't have it.
This is what I had.
Okay.
The audio visual.
Oh, you just had it. Okay.
I'm going to show you what will be marked as defense 1. Looking at the front page of that in photo lineup. Can you tell me that there are changes that are made on your original and the one that was provided?
There are.
And the changes that are on there are witnesses. There's nowhere written on the copy of defense 1 that the witness signed. Is that correct?
That's correct.
And
So I want to make sure I follow this. Witness as in Mr. White, or a witness to the process, like a third party?
a third party, I'm assuming.
There's a number here. It looks like a badge number, like what I did. I don't know if that's Will Johnson's witness signature. I'm not sure.
But the signature of the gentleman to whom you showed the array is because he was signing with his bad hand. It's that scratchy thing that's on both those.
All right.
Okay.
And it's the same on both these copies.
So what's different, and I'll let you continue, but I just want to make sure I was following because witness confused me. What's different between what is states 1 and whatever you've got, despite not having received a lineup, whatever you've got, Mr. Webb, doesn't have that other law enforcement signature that would be, we'll call it a witness to the process.
Exactly, and there's another marking as well that's different on the front of the thing. So let me rephrase my question. Here on space 1, we see that there's a witness signature here.
Correct.
But you were the only witness in the room, isn't that correct?
In the room, yes.
Okay, and here there's a line that's drawn that says witness Mr. White.
That's right.
Who is that?
I don't know.
Are any of the photos numbered when you show them to a potential witness?
Sometimes we number them on the back. I didn't see it on those, so I'm not sure.
Now, what time did the person that's said to be Amir White, did you ever get any identification from Amir White?
I did not.
So you don't know who that person was?
I don't.
And the person said that they were 75% sure that the person that they had chosen was the person that was involved in this?
That's right.
I may have asked you this, but I want to make sure I have clarified for the record. Do you recall what time Mr. Amir White, or the person that's assumed to be Amir White, arrived at the police station?
I don't.
When were you given, or did you create this lineup? Who created it?
I assume it's now Sergeant Will Johnson. At the time it was Detective Will Johnson. But I can't answer that. I'm not sure.
What is your badge number?
58.
Gosh, there are not a lot of people in, it's like just 2 digits. Just because Sandy Springs is small.
Originals.
All right.
There were 86 of us, I think, originally.
All right.
Yes, sir.
In your lineup, or in what you consider to be your lineup, you actually showed each individual photo one by one. Isn't that correct?
Yes.
They weren't all shown simultaneously.
No.
That's all I have at this time.
Ms. Hall, any redirect for Sergeant Williams?
One moment, Your Honor. If it's necessary for him to know she was a victim, is what he was saying, like he's present. Because he said he didn't know, he don't know what to do with his wife. But he's not part of the case. He just went in there and presented the line to. No further question.
All right. May Sergeant Williams step down?
Yes, sir.
Thank you, sir, for being here.
Thank you, sir.
Do you have any other witnesses that you want to call, Ms. Hall, in connection with the motion to suppress the identification that's at issue here?
So, as you know, Your Honor, it's a 2-part motion. So if you're ruling that the presentation was suggested, then I would like to call the actual witness in, who is unavailable today. He is out of state.
Meaning Mr. White.
Mr. White, yes. So yes, if that's what your ruling is, but if you're not ruling that, then we have no further witnesses for this presentation.
Okay. Mr. Webb, do you plan on calling any witnesses at this point in connection with this motion?
No, Your Honor.
Tell me what you would like to be able to review to let me know through Ms. Nelson whether you want to get us back together either for the presentation of evidence or for additional argument. I think we can have some argument now based on what's been admitted, but I'm appreciating that some of this is just in for you. And so you're certainly entitled to process it And then you may be in a better position to say, hey, the case of Jones versus State is right on point. You can't use 6 photos in an array. We all know it's got to be 20 photos, or whatever the situation is. Tell me how much time you'd like, and it needs to be not much time because of this interstate detainer that we're working through, to process the newly received information before you can say arrest on the record, or here's what else I want to tell you.
I would actually, Your Honor, like to get that copy, what we just saw.
The digital thing or the paper?
Yeah. I'm assuming that there was volume. I mean, when it was playing, I didn't really hear that much, but I would like to hear what was being said in the room.
Okay.
With that witness.
Yep. Okay, that's it. All right. We'll make sure that that happens. Now, I have a copy now in the form of States 2. I'm going to hold on to that because it's part of the record. But Ms. Hall, that can't be a very large file.
No.
What's the most efficient way for you to get to Mr. Webb that file?
I can hand it to him today. It takes maybe 2 minutes to copy.
Great. Let's make sure Mr. Webb leaves with that on a disk, a thumb drive, whatever your office churns out. Any argument you want to make, Mr. Webb, as to why that presentation and identification was problematic constitutionally?
Your Honor, we don't know who the person was. The officer that testified said he never asked him for his ID. We don't even know if that was Amir White. Who says that that was Amir White in this video? I don't know Amir White. I'm sure the state probably don't know Amir White. So how do we know that that is Amir White in this video? He says, I didn't check any identification. I just showed him 6 photos. So we don't know that that was in fact a person known as Amir White. And then in addition, the photo lineup that the state introduced as States 1 and what they provided to me is 2 different things. It doesn't have the other witness name on it, and it doesn't have Mr. White / witness. I don't have that information. I don't know who that person is. So the 2 witnesses that were supposedly in the room have not testified. And this particular witness who did testify today said that he was the only one in the room based on the state's presentation. When she asked was who was in the room, just me and the person known as Amir White. So where those other 2 witnesses came from, I don't know. I don't know how that particular lineup is in fact the original lineup in this case, but it wasn't provided to me. But what was provided to me, which I will introduce if necessary once we come back, is what I showed the detective today.
So you're using the term lineup, I think, a little loosely. The only thing that I saw that had additional writings on it was the admonition form. I didn't see any photograph that had additional writings on it. It was the admonition form that had a signature of a witness, and then down at the bottom it said Amir White witness, something like that. So we're clear, that's the admonition form. That's not the array or the lineup. I don't think you elicited any testimony that there were additional writings on any of the photographs, but if that's part of your contention, I want to make sure I understand that.
No, that's not.
Okay, got it. So I understand your 2 areas of concern. Anything else?
No.
And I'll let you, to be clear, when you leave today, you're going to have a copy of that brief exchange between Sergeant Williams and Mr. White. You'll get a chance to review it. And by the end of the week, you can let Ms. Nelson know if there's anything else that you want to add to your argument, or, you know what, actually, we all got to get back into court and we'll make that happen. If your review of that video prompts something else, because I understand you saw and heard it for the first time. You saw it pretty clearly, a little harder to hear everything that was said. But your review shouldn't take all that long. It was a pretty brief encounter. Ms. Hall, anything you want to say in response to the arguments that Mr. Webb raised?
Your Honor, I just wanted to know that it wasn't important that Sergeant Williams knew who was sitting in the room that he was presenting his lineup, his array to. What was important is that he didn't suggest anything and that he just presented and allowed that witness to choose who he thought was the person that took his items that day, Your Honor. But I also wanted to keep saying Amir. His first name is not Amir, it's Riccotto, it's Riccto.
Where did Amir come from? I thought someone said that.
Mr. Webb has been saying that because that's the part of the evidence. His name was Amir. His friend, our victim's friend Amir, was involved in this, but his actual name is Riccto White.
Riccotto.
White.
Okay, but Mr. White, we've got the last name correct.
That's why I put Mr. White, but
Got
I
it.
just wanted to make that clear for the record. But I just wanted to point out that it wasn't important that Sergeant Williams knew who he was presenting in lineup to, but more so what happened when he presented it to him and what he did and didn't do in that presentation.
Got it. Okay, thank you. So I will take this under advisement. I will not enter an order before the end of this week to give Mr. Webb a chance to review that video. Before we close the loop on Mr. White and recordings, is there a second recording of Mr. White interacting with law enforcement when he was shown the lineup with a co-defendant?
Yes, Your Honor.
Can you get that to Mr. Webb today as well, or is that more complicated than this little one?
I can try.
Okay.
It's so much evidence that I wanted to make sure I had what I needed today.
Okay.
But I prefer, I have the whole file, it's just.
Today, Mr. Webb needs to leave at a minimum with the video you have tendered, which is where, by the way, oh, it's right there. Good. Make sure I've got it. But soon thereafter, please get to Mr. Webb the other Mr. White interview that was recorded. Okay, great. Let's talk about the speedy trial, constitutional speedy trial. Mr. Webb, when you are ready.
As the court is aware, this is the third indictment in this particular case. The first indictment that was made in this case only included the name of Lamar Hilliard.
I thought the first indictment was not your client.
The first indictment only included the name of Anthony Lloyd. I'm sorry.
Okay.
The second indictment included all three defendants, Lamar Hilliard, Marilyn Israelova, and Anthony Lloyd Jr. And then the third indictment included the same three individuals. My client turned himself into the Fulton County Jail initially when this case first started. He came and he turned himself in to Fulton County on or about, I want to make sure I get the precise dates. Give me 1 second, Jordan.
When you say he turned himself in, meaning Mr. Hilliard just showed up at the jail, or he called Sandy Springs Police, or you called someone? What was, as you understand it, what was this turning himself in process?
He was told that there was a outstanding warrant for him here in Fulton County. And he surrendered on March the 29th of 2017.
Okay.
The previous indictment was February the 17th of 2017. So after he turned himself in, his bond was subsequently denied. And then that's when Judge Downs said that we could file the speedy trial demand. And that's when we filed the speedy in this particular case. Subsequent to that, Judge Downs issued a case management order back in April of 2017, indicating that discovery and everything should have been given to the defense. And on the date of May the 9th, that is when I entered into this case. So on May 9th, when I entered, and
so let me ask you then a question that effectively Mr. Armstrong posed, although I wasn't in a position to answer it. How do you know what Judge Downs said about a speedy trial demand prior to your entry?
I actually was here. I just didn't do my formal entry into the record until that date.
Did you argue bond for Mr. Hilliard?
I argued the bond.
So you were his lawyer in fact, if not in law, because you hadn't filed your appearance.
Right.
Okay, so your recollection is a firsthand recollection.
Yes. And after I did the entry, we had the bond hearing. I'll go back. We had the bond hearing on April the 26th of 2017. The next week is when I filed on May 9th, I filed the entry of counsel and my discovery motions.
Okay.
On May the 19th of 2017 is when I filed the demand for speedy trial. After I filed that demand for speedy trial, the state re-indicted the case. They re-indicted the case under the second indictment, which is,
well, it'd be the third indictment because you wouldn't be involved until the second indictment. Mr. Hilliard wasn't in the first.
Correct.
So if they re-indicted, that would get us to the case ending in 402, which is what we're handling now.
No.
There are 4 indictments?
The first indictment was 17SC149465.
And that did not include your client?
Correct.
Okay.
The second indictment was 17SC149788.
And that needs to have been an indictment that occurred before March 29th. Why else would your client be turning himself in?
Right, but that was filed on February the 17th.
Okay, that's fine, but that's an earlier date than all these other dates you mentioned.
Mm-hmm.
Okay.
And then the third indictment the case was re-indicted. So I want to make sure that I get the dates correct. The case was re-indicted. And then on 6/29/17, the initial case was null pros. So after it was null pros, Mr. Hilliard was released from the jail. After
even though he wasn't on the initial indictment.
Right.
Okay.
Well,
when you say initial case, you mean the initial case that he was on. So the second indictment.
The second indictment, correct. So the second indictment he was on, the state re-indicted under 17SC152402, that case on June the 9th of 2017.
Okay.
I know it may be a little confusing, but
no, I think I recall This is a reason why chief judges have tried to convince the clerk's office and the district attorney's office to use superseding indictments with the same case number. So things like this don't happen, because then indictments don't get dismissed. You add charges, you add defendants. This is a classic example of the consequences of not doing that. So there's the third indictment in June of 2017. The second indictment, the first on which your client appears, is null prost. The jail sees null prost. Mr. Hilliard, you can go.
Mr. Hilliard gets on an airplane, goes back to Pennsylvania, and then he's rearrested. When he's rearrested, he's held there. And when the notice for trial comes up in August of 2017, because he's being held in Pennsylvania, he's not able to say, I'm ready for trial, because the state hasn't gotten him, even though they know that he's in Pennsylvania, but the state haven't done a production order to bring him back like they did now. So in essence, he has been in custody for 4 years since this particular incident occurred, and has been waiting for trial, and has announced that he was ready for trial at that bond hearing. Once it was denied, I told the judge at that time we would be ready to proceed at trial. She said, well, file your speedy trial demand. And that's why I did that. The state, to my understanding, I received that detainer order today in court. I didn't have a copy of it. It hadn't been filed in the court's record. So I wasn't even able to actually have a physical copy in my possession until today here in court. But it's my understanding that the state sent for Mr. Hilliard to be brought back for this particular trial. And after they presented the paperwork, he then called our office, and I told him to sign the paperwork so that he can be brought back for the trial. And that's why we're here. And he's been back to the jail since he was brought back from Pennsylvania. I'm sorry, Ohio.
So a little part got fuzzy for me. Your client is erroneously released. He doesn't stick around or reach out to you. He hops on a bus and goes to Pennsylvania. He's arrested in Pennsylvania because the DA's office realized, uh-oh, here's what happened. And so the arrest in Pennsylvania is related to these charges? Or is he arrested in Pennsylvania for something different? They run his name. And not only are you wanted in Pennsylvania because of X, you're wanted back in Georgia because of Y.
He was arrested on the expressway with his girlfriend. And once they ran his name, they found out that there was an outstanding warrant because the sheriffs were looking for him.
Why was he arrested on an expressway in Pennsylvania?
Because there was an outstanding warrant for these charges.
But did they have a special facial recognition scan? Why was he stopped on an expressway in Pennsylvania?
The girlfriend that he was with at the time, she was speeding.
Okay.
And in the process,
so it was a traffic stop.
It was a traffic stop.
Traffic stop. Hey, passenger, could I have your ID as well? Oh, look at that. We struck a jackpot. You're wanted in Georgia. So it may have been everyone was going to be allowed to leave because it was just speeding. Mr. Hilliard was not allowed to leave. He's taken into custody on these charges.
Correct.
How does he end up in Ohio?
He was with his girlfriend going where?
Yeah, like it happened in Ohio. Y'all keep mixing Pennsylvania and Ohio up. I got pulled over in Ohio.
Well, I'm talking about Pennsylvania because your lawyer's motion talks about Pennsylvania law enforcement.
It should be Ohio. I'm sorry.
Okay. I will drop Pennsylvania from our discussion. So there's a traffic stop in Ohio. They run your client's name. He's wanted in Georgia. But your client's been sitting in this Interstate Detainer Act there's a drug case your client has in Ohio. He's done some time. His maximum release date is next year. Where does this drug case fall in the timeline that we've been talking about? Because that's meaningful. If he's in custody in Ohio serving a sentence, that gets weighed differently for a constitutional speedy trial.
But he was pulled over and taken into custody based on the charges here in Georgia. That was one of the reasons why I did the motion to suppress statements, because the officer at the time goes into a series of questions about what happened at the shooting. And there were statements that were made according to the discovery that we received. And that was one of the reasons he had asked for an attorney. And that was one of the reasons.
Sure, your motion that we're not talking about right now makes some allegations that would make it pretty problematic for those statements to come in. But that would require, I think, someone from Ohio who's not here today. But that didn't answer my question. Where in the timeline does the Ohio drug case fall? How is it that your client is actually serving a sentence in the Ohio state system right now?
Could I see the detainer thing that you guys received today? Because I don't have a copy of it.
Okay, but forget, yes, you can is the answer, but you can ask your client, did he plead guilty? Did he have a trial? When are the drug allegations? Are they after he left here because the jail let him go? Or he had a case out of Ohio before this shooting at the dollhouse ever happened?
Before the shooting of the, I mean, 2008 that they got up with me, 2017.
The charge that he's in custody for was from 2008.
Okay, so older case.
Yes.
And so he had other business that caught up with him in Ohio that he's serving a sentence on now, but it's not, as I understand it, that when he was in Ohio, he went into custody in Ohio because of that case. And only after he was in custody on the drug case did people put together, wait, you've got this Georgia case as well.
On the expressway is when my client indicated that the officers questioned him about the Georgia case.
Okay.
So then he's taken into custody and he's been there. And then he received a notice for the detainer to be brought back to Georgia. And I told him to go ahead and sign it so that he can come back so that we can handle these charges.
Okay, and like I said, you're more than entitled to getting that detainer information and you'll weave it in as you see fit. I didn't know where the Ohio criminal activity, when it occurred before, and your client is saying, well, long ago. But I'm in Ohio, it catches up to me and I deal with it. And when is the Ohio traffic stop?
March. I want to be precise.
What date was it? It was when I left from here, July 4th, 2017.
July 4th.
That's when I was in the country.
Your Honor, the defendant was taken into custody on July the 4th after he was released from here. I'm sorry. No.
It was July 4th.
July the 4th of 2017 was when he was mistakenly released. He was rearrested.
July 4th. I was rearrested the same day, 7 hours later.
7 hours.
About 7 hours, I was rearrested the same day.
That's some bad luck. All right, 4th of July starts well for Mr. Hilliard, released from jail on serious charges. What's going on? Going to Ohio. Same day ends poorly for Mr. Hilliard. Girlfriend driving too fast. He shares his info and somehow there's already a warrant in the system. He's taken into custody and there we are. That's what you're contending that the facts are.
Correct.
Okay.
Looking more at the notes here, July the 4th, 2017, he's released. He's picked back up on that date. Then the trial notice comes on August the 2nd of 2017, which is almost 30 days later.
August 22nd, you said?
August the 2nd.
Okay. And I think what Judge Downs did was put this basically in judicial hold because she concluded that Mr. Hilliard was not available for trial because he was in custody out of state.
Sure.
All right. Okay, so how does this amount to a constitutional speedy violation? I know you've got a statutory speedy argument, but that is contingent upon a transcript we don't have yet, so we're tabling that.
Because of the 4 years that has transpired, it's actually 4 years today. To the day. Those 4 years, you know, he's been in custody on these charges and has yet to be tried. Witnesses, evidence, things that I'm sure would have been available. I contacted the telephone company regarding some of the information that the state has provided. And they said that the telephone records are now purged, so can't get those to be able to create the defense as far as where Mr. Hilliard was on that particular date of this particular incident. So it really hampers my ability to effectively represent him in this case. And because he's been in custody, he's just languished in the jail. I know that 2020 has been a year of COVID, but prior to 2020, we had 3 years that still nothing has transpired on his case. And since this year has began, we're now in the month of August and nothing has transpired yet on this case. So all of that prejudices my client in his ability to be able to not that he's required to prove anything, but
to mount the defense that you'd want to mount on.
Exactly.
Okay. I understand that. All right. Well, you'll have final words since it's your motion. Let me hear from Mr. Armstrong.
Do you prefer us at the tables or at the podium?
I prefer you audible. So if you're audible there, that is fine with me.
Am I audible currently? Miss
Rivers, is that good?
Rivers.
Great.
Okay.
Carry on.
Yes, Your Honor. I just wanted to let you know that it seems that the Ohio database indicates that he is serving a 5-year term and that his early expected release date is June 30th of next year. Because I wanted to clarify that particular issue. From what we have in our GCIC, only because it's relevant to what Mr. Webb said in his presentation, it appears that the current sentence that he has is not from the 2008 issue. That's cycle 1 on his NCIC. He's currently in there on a 5-year sentence for cycle 3. Both cycles 2 and 3 indicate, well, everything basically indicates that, yes, there was a 2008 case, that's cycle 1. And it looks like he was arrested on that in 2017, but in September is what the NCIC suggests. So we might have to find out more information about that. But cycle 3 is what he has a 5-year sentence on, and that indicates that he was arrested in September of that year, not the same day as his release from Fulton County. Ms. Hall indicates the information that she has about his arrest. Yes, he had the prior warrant out for him, but that he had a kilo of drugs in his possession at the time that he was arrested. And so that's what I believe the cycle 3 comes from. And so I just mentioned those things because they were relevant to what Mr. Webb had said in his presentation. The timeline seems a bit off. But I would just note that there is nothing in the record that indicates that Judge Downs granted him a right to file an untimely speedy. I encourage everybody, prosecutors and defense attorneys, that if they have a particularly important decision from the court, not to just assume somebody will magically transcribe that if it's something other than a trial, but to actually get the court to sign a document saying that. There are many reasons why it is not valid regardless of anything else. In the indictment that it was filed under, 17 SC 149788, there were no capital felonies. So 17-7-171, which is what is mentioned in the motion, is not what applies. 17-7-170 is what applies.
So
Well, there's different reasons. So
no, I'm trying to process it. The speedy demand was filed under indictment 2, first one for Mr. Hilliard, but that one didn't have does this have felony murder, conspiracy to, it's got the word murder.
The 2 counts that I know were not involved in the second indictment that are in the third indictment are attempted murder and armed robbery.
Okay, so those weren't there, so there's no 171 offense.
So they weren't there in the second one, so 171 shouldn't apply anyway. But there was no statutory speedy trial demand ever filed for the third indictment after the return of those additional charges. So it could never affect those additional charges in the first place. There are other issues with the notice. It indicates that it was served upon the prosecutor, but there's no indication that it was actually served upon the judge in chambers. The certificate of service does not indicate that. Moreover, statutory speedy trial demands require, if I can get the exact phrase, shall be filed as a separate, distinct, and individual document and shall not be part of any other pleading or document. He indicates that there's both statutory speedy trials, which are mentioned in here, and constitutional speedy trial rights that are involved here. Basically, the appellate courts have not affirmatively decided that, but they have strongly indicated that a constitutional speedy is a separate pleading, and so having both of those in there messes it up. I don't have the citation with me because I was not expecting this today.
Right.
But I can tell you that the case in which footnote 4, which I've been dealing with very recently, Zarouk versus State, Zarouk, is the one that strongly encourages litigants not to file constitutional speedies along with that, because that might violate the statute. Again, the handwritten signature date indicates this was filed on the 18th. The case management hearing was the 19th. I mentioned that just because of the different days, although Mr. Webb said he started representing Mr. Hilliard prior to his entry of appearance. One thing that is clear from both the current motion to dismiss on the constitutional grounds and from what Mr. Webb said here today is that Mr. Hilliard was not present and announcing ready for trial when trial was called on August 2nd, nor at the next succeeding term of court beyond that. That even if it was valid under 17-7-171, that statute requires that provided further that the defendant was present in court announcing ready for trial and requesting a trial on the indictment. That's in subsection B of 171, and that certainly wasn't adhered to here.
But what is what does the case law say about a situation like this one where we could quibble about whether it was Mr. Hilliard's fault that he wasn't there, but he was unable to be in court? in Georgia because he was in custody in Ohio?
It is a statute that is strictly against the defendant, and I believe, because we keep mentioning it, I actually do think that there might be a Pennsylvania case that has addressed that in the sense of they refer to Pennsylvania, interestingly enough, but I do not have a case citation for that, Your Honor. However, it is a statute that is strictly construed against the defendant because the remedy is so extreme of discharge and acquittal. But the motion that we're here today is not on the statutory speedy trial demand. That's not what they're contending. That's just as part of the constitutional speedy. The state agrees that yes, the threshold issue of a year being involved is met in the case so that it would be appropriate for the court to go on to the 4 Barker versus Wingo factors. One of the things that I would mention is that they talk about things proceeding with uncommon delay. However, for the first period of time before Mr. Hilliard decided that he wanted to leave the state and go somewhere else where he was arrested, that things were proceeding appropriately, that they were moving accordingly, because he was added to this case, as they mentioned earlier, in February, and it was already set for trial on August 2nd. And so that doesn't seem like time that should be penalized against either party. And him being in a different state for different charges does not completely obviate the state's need to bring him, but I do think that it weighs strongly against a heavily weighted time frame for that period of time. Beyond that, I would note that during COVID, there was an impossibility for trying an individual. And so that period of time, it should weigh very benignly, if at all, against the state. Now, the assertion of the right is the third factor, of course. And the fact that they even attempted an untimely statutory speedy trial is somewhat of an assertion of that right as to the charges that were involved in that second indictment. But again, there's never been such an assertion as to the third indictment. The defendant did assert the request in it appears at least by instituting the interstate detainer rules, which is what got him here. So things are working appropriately based on his final assertion in Ohio that he be brought back here. Now,
Question. I think I know what your answer is going to be, but does a defendant need to renew his speedy trial demand if the state reindicts him because the consequences are so severe, it's strictly construed that, look, if there's a new indictment, you got to file a new demand for speedy trial? Or does it carry over?
What I do not know today is if count 1 is indicted in this indictment and then it's reindicted and that count is the same. That might apply, but it's immaterial because the demand was incorrect. But it does not apply to new charges.
Okay. So the more serious charges of attempted murder and armed robbery, which were not present in the second indictment, first for Mr. Hilliard, they were present in the current indictment. There was no demand, statutory speedy trial demand made as to those 2 counts.
Correct.
So the only thing operating as to those 2 counts would be a constitutional speedy trial demand,
Correct.
Which arguably could have been triggered by the original speedy trial demand, as in the sense of, hey, I want a trial. At a minimum, it would be triggered by the interstate detainer, come get me out of Ohio because I want to deal with my charges in Georgia. Those happen to be 3 years apart or 4 years apart, but
I agree with the second part, but not the first.
Okay.
Because the first part, there's entirely reasons why a defendant would want to delay a case with more serious charges where they wouldn't want that in one with less serious charges. And so it's not easy to assume, and I'm not aware of any law that allows a speedy trial assertion as to one count to apply to other counts for which they were not made. Number 4 is, of course, the harm to the defense. The defense in their motion only mentioned that there might be witnesses that couldn't come in to testify. And that's the only harm that they've alleged from the passage of time. However, they've not identified anybody. Mr. Webb didn't mention any particular witnesses whose testimony that they could have got who've died or something of that nature, where there's more than just speculative basis to think that they could provide something beneficial to the defense. More importantly, the only issue that they have orally argued that I heard was that the telephone company has purged the records since that point in time. However, Your Honor, the delay that took place once Mr. Hilliard left the state and got arrested someplace else and started serving a sentence for a large amount of drugs is not anything that dealt with the phone records. Mr. Webb and his predecessor received discovery in this case back in 2017. Those phone records were part of discovery. They could have been obtained at that point in time, but the defense did not do due diligence at that time if they needed certain phone records to occur. Now, it probably was because as any attorney, if your defendant decides that, like, peace out, I'm leaving, then you're not going to do further things for that particular case. So I understand entirely why it happened. And I'm not suggesting there's anything wrong with that. But to say that the telephone companies purging those records is due to this delay and the defense couldn't possibly have gotten it otherwise, they could have gotten it in 2017 when this case was set for trial on August 2nd. And so there's no actual harm to the defendant that's been shown with any particularity, with any specificity. And there's one quote that I always really, really like that applies more to the two latter charges more so than the first charges, but I think still applies to the first charges based on the manner in which they were asserted. I'm reading from Dillard versus State, which is 297, Georgia 756. And I'm going to omit the case citations that are here, except for noting when there's a concurrence. Where the other factors are to be weighed lightly against.
Don't read too fast. That will be hard for our court report.
I understand. I apologize. I literally told somebody that just yesterday. So if I was violating that own rule, I literally tried to train somebody on that yesterday. And so in the instance where the other factors are to be weighted lightly against the government, quote, it is incumbent upon the trial court to find no constitutional error given a defendant's long delay in asserting his right to a speedy trial and his failure to demonstrate prejudice. In concurrence, Justice Nimius indicated, delayed assertion of the right of a speedy trial and lack of prejudice are the two factors that most often weigh heavily against defendants and which then support the overall conclusion that speedy trial rights have not been violated. I would just like to note, since I said, quote, I changed a past tense verb to a present tense verb and a name to a defendant in that quote.
Okay.
Nimius, it's Nahmias, and it's justice. If I said judge, I apologize.
You said justice.
Okay.
And it's pronounced Nahmias because you'll be arguing in front of him someday. So.
I've said it 5 different ways, and during COVID, I've forgotten everything.
Yep.
And so with that, the state suggests that taking all of that in balance, the presumed prejudice is substantially outweighed. It only has to be outweighed, but substantially outweighed by the absence of demonstrable prejudice and the defendant's own delay in asserting the right, at least to the most major charges.
All right, Mr. Webb, counterpoint, anything you want to add in rebuttal?
Your Honor, what I would say is that this defendant does not have to reassert his right. If the state indicted their case 20 times, when he filed his right to a speedy trial, that right will continue throughout all of the cases. Now,
you have a case that says that, or I'm not disagreeing with you. I don't deal with constitutional speedies every day, and I'll go back to my prior orders because they'll be rich with case citations. But I'm just curious if you believe that the case law holds, once you're in, you're always in, and then how you'd respond to Mr. Armstrong's observation that it can't be that if you file a proper statutory speedy trial demand on indictment 1, that's all about theft by taking, and then indictment 2 realleges all those thefts, but also adds a murder, that the speedy's been running on that murder.
I can provide the court with that.
Okay, you can email it to Mr. Armstrong, Ms. Hall, and Ms. Nelson, and that'll get to me. All right, but I get your first point.
Second point is that the demand for speedy trial was filed separately. It wasn't filed with any other documents. It was served upon the state. It was served upon the court. It was served upon Mr. Chong, who had the case previously. That was one of the reasons why the case was put on the August 2nd trial calendar, because there was an outstanding speedy. If I could introduce all the emails that Mr. Chong and I had regarding that speedy, I would do that. However, I can't authenticate them as being from him. So I will just state in my place that he was served separately and the court was served separately regarding both of those.
I don't know what the case law says, but my thought is if you e-file a demand for speedy trial as a standalone document, which occurred in this case, that is served on opposing counsel and the court gets it. So I didn't get the sense anything was being hidden about that. But I also don't think this case rises or falls. This motion, your motion for constitutional speedy, rises or falls on the breadth of the service.
Your Honor, just to correct a misimpression, this was before e-filing and this was filed in office in the clerk's office.
Okay, well, I still think that's how e-filing works, but this was before e-filing and I guess it's just been pushed into Odyssey. Okay, either way, keep going, Mr. Webb.
That's all I have, Your Honor.
Okay. Let me write one other thing down. Ms. Hall, you have had a support team here helping you generate discovery for Mr. Webb. Do you have something you want to put on the record that you're going to provide to Mr. Webb right now?
Yes, Your Honor. My colleague was gracious enough to follow along on YouTube and come and make a copy of the interview. So it is the interview for Mr. White.
When we say interview, there's been reference to several interviews.
It is the array of, this is a presentation of the 6-pack array that was presented here in our motion today.
Sergeant Williams and someone that you're saying is Mr. White.
Yes, Your Honor.
Okay, all right. And that's on a disc that you're going to hand to Mr. Webb.
And it's when I'm have him sign our folder to indicate that he received it.
Great.
Can I put it in your computer to see if it works?
Sure, yeah.
We'll do that. While that's happening, so Mr. Webb, why don't you go on over to Ms. Hall? Mr. Armstrong, I would ask you to put your math cap on to be thinking a little bit about what impact, if any, the Interstate Detainer Act demand, whatever it's called, has on when we would need to try Mr. Hilliard's case if I don't grant the constitutional speedy motion.
Yes, Your Honor. And I would like to start this conversation by stating that interstate detainers are one area of law that I do not independently have knowledge of.
One of the three.
Well, I just wanted to make sure that was clear because the answer is I don't know, but the most conservative answer is Monday.
Meaning if he's not tried by Monday,
the trial doesn't begin by Monday because the document was signed. Whether we received it, I don't have that information here for you today. But if it is exactly 180 days from the date of the interstate detainer, their date was February 10th, 2021. If you use a date calculator online, 180 days is Monday, August 9th, 2021.
Okay.
However, any request for continuances like have been made here today, that would obviously, the case law that I was able to find indicates that that is not an inflexible date. And so that if there is continuances, that 180 days is not inflexible, especially if it's a defense request for continuance, which I believe was requested today.
Okay.
I don't have a CD player.
No, I got this.
Oh, okay.
Just super long.
Come on, Wake up. Come on. Okay. Use that computer. Is it not in there?
I don't think we can use it because it's connected to all this stuff. That's why he makes us do the Zoom.
Your Honor, is there a CD player in the courtroom that we could use that's not on the laptops? Because my computer is saying that it cannot accept an external hard drive disk, essentially. And so it doesn't have an independent CD player in the laptop, and the external one is what seems to be the problem for me.
I don't think so, given all these new computers. So, Mr. Webb, you're going to take the disc and you will let Ms. Hall and Ms. Nelson know before you go to bed tonight whether what's on it is what we hope is on it, as opposed to files from a rape case or a different interview with Sergeant Williams. But I appreciate you wanting to confirm it before you leave, but you can let us know tonight. Mr. Webb, my thought about a trial date for your client is that it needs to be soon if there is going to be a trial. I need to obviously rule on the constitutional speedy request. It turns out that we have a bunch of jurors coming on Monday and Tuesday. I don't know that it is in your client's interest or the state's, but I'm more focused on your client's interest. To say, great, let's start trial on Monday in terms of you being prepared, et cetera. But my commitment is to first rule on these motions and then second, have a trial in the case. I will have jurors every 2 weeks between the end of August and the end of the year for criminal cases, not civil cases. So it will be an easy task to specially set this, because it sounds like there are witnesses coming from out of state, et cetera, so that we've got a date certain for your schedule, a date certain for Mr. Hilliard, so he knows it's happening, et cetera. But I need your guidance on this, because if you're not comfortable with that, then the state's going to need to engage their subject matter experts on the Interstate Detainer Act to see if Monday is in fact the deadline. But you sort of hold the keys here, because if I'll let you talk to Mr. Hilliard about it, but if you consent to a brief extension so that we try this case in the next few months, if we're going to have a trial, got a rule on the constitutional speedy, then you'll have a easier on-ramp to the trial and we'll be there. But that's really up to you. You want to talk with your client and let me know, or you already know what you're going to do? I mean, in the end, you speak as counsel for Mr. Hilliard.
Once I review this, I'll know.
Okay.
If I can review this today, I can tell the court right now, because my clients basically told me I'm ready to have this done
Okay,
I'm ready.
so you could try this case next Monday. All right. Then state, you all need to figure out if Monday is our drop dead date. We have jurors and we can figure out how to make that happen. I know that may mean moving other mountains, but if the case is going to be dismissed by operation of law, short of that, I don't know if we've got another option. But you will have a chance to think about it because it's Tuesday. And it may be, number one, that Monday isn't the end of that window because of reasons that Mr. Armstrong mentioned. And it may be that there is a motion you can file that would, if I grant it, authorize extending that deadline. We find ourselves where we are based on the Interstate Detainer Act. And I too am not an expert on its operation. I just know that it can sneak up on people as a sort of silent speedy trial demand. So you may want to involve others in your office in thinking through that, but I will need some input from the state side in the next day or so, because if it does have to be tried by Monday and the state wants to go forward with it, Mr. Webb is saying he's ready. And unless you want to dismiss the case, we have to try it by then. And so I need to start elbowing some people out of the way to get us on Monday, if it has to be Monday or Tuesday. We'll have jurors on both days, Monday and Tuesday.
Your Honor, can I just, somebody sent me some information about the possibility of a continuance, and it might have to happen in open court with the defendant here. So can I just read it aloud so we can all read it all at once?
Sure. I guess the other thing I'd ask your team to be thinking about is the impact. You couldn't file a speedy trial demand that had any traction by Supreme Court order for many months. And anything that Mr. Hilliard did in terms of an Interstate Detainer Act demand would have fallen in that time. In other words, Chief Justice Melton's order said, you can ask for a speedy trial demand, but no clock starts running until, and I don't think it started running in Fulton because of what Chief Judge Brasher did.
That's entirely possible, Your Honor, because it did toll all of the things, essentially, is what it said, but it does not say the word interstate detainer. I searched while I was sitting here with Ms. Hall. It did not say that. But what I'm going to read is OCGA 42620, Article 3, subsection A.
All right, hold on. I'm going to get it on my screen.
And I'm going to read it slowly for your benefit, Mr. Webb, as well.
Okay, but still hold on. $42,620. 20. Okay, it's only 1,000 pages long. Where are you in it?
Article 3, subsection A.
A?
Yes, because it's an interstate detainer and has multiple states, they use their own way of referring to things.
I'm at 3A.
The first sentence begins, whenever a person has entered upon a term of imprisonment in a penal or correctional institution of a party state, and whenever during the continuance of the term of imprisonment, there is pending in any party state any untried indictment, information, or complaint on the basis of which a detainer has been lodged against the prisoner, he shall be brought to trial within 180 days after he shall have caused to be delivered to the prosecuting officer in the appropriate court. So it could be that it was 180 days from when he was brought in May 20th. And so Monday would not be the drop dead date for that. But I'll begin again where I just left off. Within 180 days after he shall have caused to be delivered to the prosecuting officer in the appropriate court of the prosecuting officer's jurisdiction, written notice of the place of his imprisonment and his request for final disposition to be made of the indictment, information, or complaint. Provided that for good cause shown in open court, the prisoner or his counsel being present, the court having jurisdiction of the matter may grant any necessary or reasonable continuance. The request of the prisoner shall be accompanied by the certificate of the appropriate official having custody of the prisoner, stating the term of commitment under which the prisoner is being held, the time already served, the time remaining to be served on the sentence, the amount of good time earned, the time of parole eligibility of the prisoner, and any decisions of the state parole agency relating to the prisoner. So, going back to that horrible phrase, within 180 days after he shall have caused to be delivered to the prosecuting officer in the appropriate court of the prosecuting officer's jurisdiction, written notice. And so that would be the document back in February.
So it was received on February 9th?
It was dated February 10th. I don't know when we received it.
Dated as in signed in Ohio? I don't have it in front of me.
Yes, I believe I gave my copy to Mr. Webb. If I can have it back. May I approach, Your Honor?
Sure.
This is the document that I have, and it's dated February 10th. From Ohio. And I will inquire whether those documents that are required to be along with it were delivered to us by Ohio.
Do you know if a detainer was lodged again? I assume Ohio would have confirmed that there was a detainer lodged against Mr. Hilliard before they would send this to us.
Was there a detainer? Did we detain? The short answer is almost certainly, but we will absolutely check to see. Because of his charges, we typically get detainers on individuals who are charged with armed robbery and attempted murder.
Certainly didn't make it into the docket, which would be the way the court was notified. Because the notice is to be delivered to the prosecuting officer, and it is addressed to Fonnie Willis, and it's got the indictment number on it. The appropriate court would be Superior Court, and it looks like it went to the clerk of court, but they didn't get it into the docket for this case. So it wasn't made clear to me that this was pending. I am going to grant a necessary continuance up through and including the end of this year, meaning that Mr. Hilliard does need to be tried in calendar year 2021. The basis for that continuance being the ongoing judicial emergency that the Chief Justice of the Supreme Court of Georgia declared many months ago, that was in force in February and March of 2021, when this was filed, and when it would have been delivered to either the district attorney's office, or it needs to be delivered to both, the clerk of court of Superior Court. At that time, had Mr. Hilliard, through counsel, filed a timely, proper statutory demand for speedy trial, it would have been filed, but it would have been told. And I find that for all the many important public health and public safety reasons that our Chief Justice imposed a tolling on speedy trial demands, those reasons apply with equal force and with equal purpose to Interstate Detainer Act demands. It appears, I'm not making this ruling, that Mr. Hilliard complied with the requirements of OCGA 42620, the Interstate Detainer Act, as it's incorporated into Georgia statutory law. I don't need to make that finding because of the continuance that I'm granting. But so the state is clear, and this is on the record in open court. Mr. Hilliard is here, Mr. Webb is here, 2 lawyers for the state are here. This will need to be tried in less than 180 days from today, because the end of the year is much closer than that. I'm happy specially setting it. We need to work through a few matters to close out these pending motions. But if Mr. Hilliard's case is not tried as 2021 draws to a close, which, by the way, he'll still be under sentence in Ohio for his drug case, then I will find that whatever the impact of the Interstate Detainer Act demand that Mr. Hilliard filed will have taken full effect. And by operation of the Interstate Detainer Act, the case will need to be dismissed if it's not tried. Mr. Webb, I invite you to get on the record any objections you have to that continuance. It's certainly not anything you requested. I think we were on the record, but you made clear that assuming that CD plays, you're ready to go on Monday, August 9th.
For purposes of the record, I would announce ready for trial in the matter of the state of Georgia versus Lamar Hilliard in indictment 17 SC 152402. The only outstanding issue that I brought to the state's attention today was the issue about the audio and video of Mr. Amir or Rico Amir White. That's the name that's in discovery. And the second or the third video of Damian Sanders. Without those particular items, I wouldn't be able to go forward, but for purposes of what the state provided to me here today, I'm ready to go forward, and I would just place my objection on the record for the continuance in this matter.
Ms. Hall or Mr. Armstrong, anything you want to say about my continuance, which I want to be clear, I'm granting it sua sponte. I didn't hear a request from the state. I saw some very, very wide eyes when I said, hey, you may need to be ready to go on the 9th. I'm thinking of the right way to balance the competing interests of Mr. Hilliard in seeking closure in this case from 2017, and the state and the people of Georgia's right to have this case prosecuted properly, et cetera. And given the restrictions that were put in place through the judicial emergency continuing orders that were renewed monthly, one of which, and one of the primary ones on the criminal side, was this tolling of speedy trial demands, I think that the right approach is to handle Interstate Detainer Act requests as we would speedy trial demands. And so something that was filed in February is noted, but that clock doesn't start running. I'm probably truncating it in a way that the state could object to, because in Fulton County, if Mr. Webb were to file a speedy trial demand for a case that was indicted yesterday, it would be told right now. It wouldn't start running because Chief Judge Brasher has extended, as he's authorized to do under a law passed this legislative session, he's entitled to extend that moratorium, if you will, on speedy trial demands. So in this jurisdiction, the clock hasn't even started running yet, but I am holding that for Mr. Hilliard's case, we need to resolve this case one way or the other by the end of the year, or it will stand dismissed. Anything the state wants to add?
Only that a request was going to be made, but not necessarily as detailed as Your Honor made it based on the judicial ongoing issues that have been occurring because of COVID. But yes, we were not happy with the idea of going on Monday, but that was a reality that, wide eyes or not, we understood that we were going to have to exist with, if not a continuance.
Okay.
So thank you for granting that.
Ms. Hall, you need to, one more time, get to Mr. Webb, disc number 3 of Damian Sanders's interview. Any reason why that can't happen by the end of this week?
No.
Assuming you've got a disc number 3. I mean, you either need to tell him it doesn't exist and be an issue for a jury to work through as to how the 3rd disc disappeared. You need to confirm through, it sounds like it would be Detective Johnson, whether there is a recorded interview of Brad Thomas. And there's one other interview of Mr. White where he is shown a photo lineup with Mr. Lloyd in it. Mr. Webb needs that. So however you want to make the handoff, I guess if you certify, look, I've looked at these discs and this is what's on those discs, that will suffice for me. It's probably easier if you and Mr. Webb can meet up so you can press play and he can sign something that says, I've seen what's on these discs. And it is in fact, disc 3 of Damian Sanders and Mr. White's first interview. But those are must-dos so that I appreciate Mr. Webb saying he's ready to go as of Monday. He can be even more ready by having had a chance to review those items, which could be fertile ground for cross-examination. Who knows? But he's certainly entitled to them. I think that will address discovery. The last thing, I know it's 5 o'clock and I appreciate everyone's patience. We need to make a plan for working through Mr. Webb's 3rd motion, which is the Ohio, not Pennsylvania, statements. And it sounds like Mr. Hilliard said some things to Ohio law enforcement and then maybe unbeknownst to Mr. Webb, which could be another discovery issue, it may be that Mr. Hilliard was interviewed by the FBI as well. And what drives this whole discussion is what does the state want to use? If you're not planning on using any of these things, Mr. Webb's got them and he may choose to admit them, but if you're not, then there's nothing to suppress. But if you do intend to use statements Mr. Hilliard made to Ohio law enforcement or the FBI, I assume that's in Ohio somewhere. So basically law enforcement writ large in Ohio, then we need to have a hearing on this motion sometime before trial. It can be close in time to trial if those are witnesses who'd have to come in for trial, so they don't need to come here twice. So it's basically a Jackson Deno, and Jackson Denos can happen on the eve of trial. They're not, the legal issues usually aren't all that complicated. If the guy didn't Mirandize him and it's something substantive, we all know what's going to happen with that. If you did Mirandize him, and probably coming in, but it depends on context. Have you reached a point yet, Ms. Hall, as to whether you know if you're going to try to use any of the out-of-state statements?
So, Your Honor, first I just want to highlight the fact that I believe this motion was filed correctly. I know we switched it to Ohio in the midst of Mr. Webb talking, but his date and his state is correct as far as this motion that is filed.
Oh.
So the state had no intentions on using the statements that were made. Well, we're not aware of any additional statements that were given to the Pennsylvania law enforcement officers that pertain to our case. So we were not intending to introduce those statements into trial. If I find out that there are statements, then I will obviously bring that to the court's attention. However, the confusion is there were 2 stops made.
Oh.
There was a stop made in Pennsylvania when, after we indicted the defendant on the 17th of February, a stop was made in Pennsylvania on March 1st, which the motion indicates, where he then turned himself in and he was booked in Fulton County March the 29th, which was towards the end of that same month. But then when he was released by mistake by the Fulton County Jail July 4th, he then went to Ohio and was arrested the same day. That's when.
Possibly the same.
Okay.
Possibly, well.
We don't
at
know.
least what I know is that it went into the next day, so it's the 5th.
Either way,
But that is a completely different.
you're not aware of custodial statements made to Ohio law enforcement.
Correct.
You're aware of, in fact, Mr. Webb was correct, Pennsylvania law enforcement that are made after the shooting, but before Mr. Hilliard had his arraignment in Georgia.
That is correct.
Okay, I didn't, that makes more sense then. I didn't understand, that there was there were 2 out-of-state arrests. Do you know why Mr. Hilliard was dealing with law enforcement at all on March 1, 2017?
That was also correct. That was a speeding incident. So he was
Okay.
pulled over and questioned because he was, that now there's a warrant out for him in Georgia for his arrest for indicting him.
So if we take Mr. Hilliard's word as to the July arrest, he has the exceedingly bad luck of having been stopped not once, but twice for speeding, whether he's the driver or the passenger, the result of which is, because the stop has nothing to do with this case, but the car that gets pulled over for speeding has Mr. Hilliard in it, and both times it results in him going into custody in connection with these charges.
Well, I don't want to put on the record that the second stop was for speeding.
You didn't, Mr. Webb did.
Because I believe that involved Mr. Hilliard trying to get a passport, and then we were notified, and that's how he was taken into custody with the kilo and all that situation.
Okay.
But the first one, yes, indeed, was speeding. The second incident he did, unfortunately for him, get caught from law enforcement officers right after he was released.
Okay.
And then they dealt with that situation, which in turn came into a 5-year conviction, and now we're back here.
Got it.
But when he was pulled over in March, he was told that there was an outstanding warrant. The officials in that state allowed him to turn himself in. That's when he came from Pennsylvania and turned himself in to the jail.
Okay, but something about, to get back to your motion, Mr. Webb, something about the interaction with your client and Pennsylvania law enforcement resulted in some statements that the state wants to use, and you flagged a bunch of reasons why you think they ought not come in.
Right.
Okay, got it. So we need to have a hearing on that. In order to get those statements in, you'd need those law enforcement officers anyway for trial. So I think it makes sense to do that hearing on the eve of trial. I don't mean 10 minutes before the jurors come in, but if we'll figure it out. But that would be my thought, is to defer this motion until we're closer to trial. And Mr. Webb, if you can make a good faith argument as to, what Mr. Hilliard is going to plead, if those statements are coming in, then we can have the hearing sooner. But if that's not going to move the needle, then I would prefer to have the hearing on your third motion closer to trial, so that these officers from Pennsylvania only need to come here one time.
The previous DA, Mr. Chong, when I spoke to him back in 2017, he says there were no statements. I only determined that there were a conversation between law enforcement and my client when interviewing him. So that was out of an abundance of caution that I filed that, because I didn't want them to come down and say, oh, he said this, that, and other. And I'm like,
yeah. So I guess the way we'll handle this is, Ms. Hall, you'll need to figure out, are these, if you're going to call anyone from Pennsylvania, and if so, are they going to talk about statements that Mr. Hilliard made? If so, they are not talking about statements Mr. Hilliard made to them until we litigate Mr. Webb's motion. So we're clear. You can call any witnesses you want. No one is talking about anything Mr. Hilliard said in the state of Pennsylvania to law enforcement until we have a chance to litigate this motion.
Understood.
Okay. All right. I think through your all hard work, we covered everything. Anything else, Mr. Webb, from your side of the equation?
I spoke to Ms. Hall. She said that she will get me the returns on the phone records, the returns, where they took out the extractions,
Remember, that was the 401, 402.
the 41 and 42.
That's in the evidence.
But what was filed, I did see online is that there was a return and it says that there was one page of something. I don't know what that page is.
All right, I'm gonna let you guys not on the record work through that. And Mr. Webb, your job will be to let Ms. Nelson know if you are having continuing difficulties getting information from the state. Okay? Ms. Hall, anything else for the state?
Nothing further from the state, Your Honor.
All right, Mr. Armstrong, thank you for parachuting in. And Ms. Nelson will reach out to you, Mr. Webb, and you, Ms. Hall, fairly soon and say, here are a couple calendar dates where it's our jury day. Mr. Webb, just for your information, you can go off the record now. Thank you. At the end of August, we're going to judge specific calendars, trial calendars. And it's about every 2 weeks that judges come up. So I know what my trial dates are between now and the end of the year. And so I'll have Ms. Nelson probably float a couple days by you and Ms. Hall. And if you guys can agree on one, we can specially set this one for one of those days, meaning it would be first out. If it is resolved, we'll try something else, but at least there'll be certainty for everyone. And Mr. Hilliard will know that's not just another calendar day, it's his day. All right.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, deputies. Sorry it got late. Thank you. So you didn't ask for a break. I assume you're okay.
Oh, yeah.
Okay. Good.
Because I never give me time to get the stuff that they were supposed to give me and the phone. That's what I need to get.
Mr. Armstrong, I don't know that I need, but I'll hold on to it. This detainer thing. Okay.
Thank you very much.
Oh, I have a copy. Huh. Someone handed it, so there must have been two today because I've got one in my pile of stuff.
I think Ms. Nelson said they made a
Ah, Ms. Nelson. Mr. Webb, I have one quick question, if it's an easy answer. How do you end up with a case in Lamar County? If it's a long answer, don't worry about it, but.
It was a case that I knew someone who knew the person who had got to stop going through there.
Got it. So they were like, hey, you know who you want Webb, and boom, you're down in Lamar. Okay.
And I agreed to take it.
Ah, your mistake. Yeah.